late one with mention.
From the supplementary list, under heading for fresh filing, item 1 WPS 5802 of 2003.
Are you for the petitioner?
It is in this the petitioner has paid for payment of interest on the gratuity which was paid after the delay. That is the only prayer of the petitioner.
Who has caused delay?
Lordship, the delay is not on our end.
At whose end?
It is at end of the authorities' leadership.
Who? Which authority?
University leadership. It will be university. The petitioner's husband was a teaching staff of the Gosner College. He died.
When did the Grosvenor College send it?
Gosner College. That is not on record. Leadership.
And that is important.
Even if Gosner College is at
Just a
delay.
moment, please hold on. Who is your employer?
My leadership, my humble prayer before your leadership. If leadership takes.
I'm just
section
asking
7,
you a question. Who is your employer?
It will be Gosner College.
Grosvenor College,
Yes.
right? They are supposed to send the bills to the
university.
university, and university is supposed to send it to the state, and then state is supposed to make them,
Leadership.
right? So, if the Grosvenor College makes delay in sending the requisitions, then who will pay the interest?
Leadership, it has to be paid to me.
No.
It has to be paid to me. It is the authority who has to pay to me.
Which authority?
Because of their
So,
delay.
you are seeking a relief against Grosvenor College?
I'm leadership. The payment has to come by state.
Not necessarily. Why should
Only
state
when
bear
the-
the burden of interest for the delay caused by Grosvenor College?
Leadership, it has to bear the burden because.
Who has to know? Show me some law.
Yes, leadership.
Just
I take
show me
section
some
7
law.
of the Gratuity
Yes,
Act.
let us see payment of gratuity act. And who is for Grosvenor College?
So probably the notices have not been issued in the matter. It was coming for the first
Section
time.
7?
Section 7.
Let us see section 7.
Determination of the amount of gratuity.
Yes.
Leadership, the first one is a person who is eligible for payment of gratuity. Here the entitlement is not in dispute because they have
No.
made the payment. Now, as soon as the gratuity becomes payable, leadership, that will become payable on my date
You
of
don't
retirement.
simultaneously comment while reading the section, right?
I have learned.
Yes.
As soon as the gratuity becomes payable, the employer shall, whether an application referred under subsection 1 has been made or not, determine the amount of gratuity and give notice in writing to the person whom the gratuity is payable and also to the controlling authority specifying the amount of gratuity.
Just a minute. This has to be done by the employer?
This has to be done
That is
by
the
the
Grosvenor
employer.
College in your case?
Leadership. It is
Then,
the leadership.
if they have not done anything, so your claim would lie against Grosvenor College, not against the state.
Gosner College is a party to this
Private
application. The
Private
notices may be issued leadership because ultimately the requisition will be sent to the state and it is only the department which will issue the amount and then it will be paid.
No, the point is that requisition on account of interest will be paid by the person who has caused the delay, that is your employer.
Even
And therefore, whether the state can be saddled with that liability to pay interest for which no requisition was ever sent is the question which is required to be decided.
leadership, when I examine that, leadership, my humble submission is my payments are made by the state when the requisition is sent by the my employer.
You
Gosner
are not
College.
understanding or you don't want to understand.
Leadership, I am just making a humble prayer.
Who is
before-
the person, according to you also, as
I-
per
I
the
wasn't-
records, as per the
yes,
records,
yes.
it is the employer who has delayed in making the requisition.
It will be the
As
university.
counsel for the university,
It will be the university.
you should also ensure
Minutes, first of all,
as to when was the requisition sent to you.
minutes, as per section 7, as we read, it has to be paid on his superannuation. In this case, when did the petitioner die?
2013.
He died in 2013.
He died in 2013
2013.
while in service.
Yes, ma'am. And the decision to make payment of gratuity of rupees 20 lakhs came in the year 2020-21.
Okay, so you forget about 2021.
Yes, ma'am.
No. this decision to make payment of 20 lakhs, prior to that there was no, they were not entitled to any payment?
No, they were entitled to gratuity to the extent of rupees 10 lakhs.
That has been paid?
That only on that I am
When
aware.
was it paid?
The prayer is solely limited to interest.
When was it paid?
We have not also
My-
filed counter in this case. So let us also file counter affidavit and notice will be issued to Gosner College.
That litigation.
You take personal service.
As you wish.
Because now the point is very clear, right? You state,
Yes, ma'am.
you take care.
Yes, ma'am.
If the matter has remained pending at your end, you will have to pay the interest.
Lordship, university had sent us requisition and not in this matter.
We do not know. We do not know. The point is, it is quite an amount.
Yes. Also,
Learned
leadership
counsel
and-
for the parties are present. The solitary point involved in the present case is, the counsel for the petitioner submits that the petitioner is only claiming interest
Interest.
on the gratuity amount which has been paid to the petitioner, being the wife of deceased employee of respondent number 4. Only on when were you paid?
Leadership, the exact date.
You don't have the date also.
Leadership, it was paid in 2020. 21/9/2020.
Such vague.
That is an annexure to leadership. My pension was fixed and gratuity was paid.
Which was paid according to the petitioner only in the year 2020.
21/9.
The husband of the petitioner had expired on
On leadership 27/2013.
27/2013. It is not in dispute that the employer of the petitioner is respondent number 4, and it is the case of the petitioner that interest on gratuity is a statutory interest payable under section 7.
And it is mandatory in nature. My prayer.
Will you give the dictation?
No, I'm just.
Mandatory, what mandatory? The learned, had it not been a statutory interest, do you think that we would have issued notice?
No.
Right? The records of the case indicate that the requisition was made by respondent number 4 to Registrar Ranchi University, annexing the arrears statement only on 27/2021. Therefore, it is required to be ascertained as to at whose instance there has been a delay in making payment of gratuity, so as to fix the liability for payment of statutory interest in terms of section 7 of the Payment of Gratuity Act 1972. The learned counsel for the respondent university and state are directed to seek instructions and file a counter affidavit in the present case. Issue notice to respondent number 4 under speed post, for which requisite should be filed by day after tomorrow. Thusly, in addition, the notice should accompany a copy of this order. Post this case on 28th of February 2023 under the heading for admission. The affidavit regarding service of notice be filed by (21st of February). There is similar matter. There is one more matter.
The next
Did you-
one. In that, there is an additional prayer. I retired in the year 2017, so I will be entitled for the arrears of gratuity which occurred due to 7th pay revision.
So here interest is not involved.
Interest is involved, leadership, as it is the 10 lakh which was supposed to be paid, it was paid with a delay. And then the arrears of gratuity which was, as per their own admission, has been implemented by revision of 7th pay revision.
I don't get it. 7th pay revision has been implemented.
Implemented
When?
and a decision to
When?
that
When?
effect has been taken in 2021. That
To implement 7th pay
to
revision.
implement 7th pay revision, and in that the gratuity was revised from 10 lakhs to 20 lakhs.
So
So that arrears, because I retired after implementation of 7th pay revision, they have taken a cutoff date of implementation of 2017 itself.
where is the cutoff date?
Leadership, that cutoff date is in that leadership. I am praying that there is a similar case which they have said.
You don't plead foundational facts for your
Leadership,
case,
that is not.
and then you come to a case. They have enhanced it
enhanced.
for whom? There must be a cutoff date.
Leadership, that
Have
is
you
not-
retired after that cutoff date or prior to that cutoff date?
I have.
And where have you mentioned?
I have
What is your
retired-
date of retirement?
I retired on 30 September 2017. The cutoff date is July 2017.
And therefore you are entitled
For
for
the revised gratuity.
revised gratuity of rupees
10
20
lakhs
lakhs.
addition.
additional 10 lakhs. When were you paid 10?
Leadership, I was paid 10 lakhs on that requisition itself, which was sent in 2021. My name finds mention in serial number 9.
So you want the balance from July 2017 to 2021 on 10 lakhs,
10 lakhs.
and then
Since my 10 lakhs was payable on 2017 itself, so the interest on that amount.
okay. And what about 20 lakhs? You want that balance also. Balance also with interest.
With interest. There was a similar matter before this honorable court.
Decided?
They have remitted my case back to the authorities filing the representation.
So that does not serve the purpose. That will not clinch the issue ultimately. That is required to be decided by this court.
As your ladyship please, I was just bringing to notice of ladyship.
Learned counsel for the parties are present. The petitioner is an employee of respond number 4, a minority institution. The learned counsel for the petitioner has submitted that the petitioner superannuated in the month of July 2017,
September.
in the month of September 2017, and by a notification issued sometimes in July 2017, though not annexed with the writ petition, the 7th pay revision was implemented and the gratuity amount was enhanced from maximum of rupees 10 lakhs to 20 lakhs. He submits that rupees 10 lakhs has been paid to the petitioner in the year 2021, but without statutory interest in terms of section 7 of the Payment of Gratuity Act 1972. The learned counsel submits that in addition, the petitioner is entitled for payment of interest from the date of his retirement till payment of rupees 20 lakhs in the year 2021, plus additional rupees 10 lakhs from the date of his retirement till the date of payment. From the records of this case, it appears that the requisition for arrear claim against payment pension and gratuity was forwarded by respondent number 4 by letter dated 27/2021. It is not clear as to at whose end the payment and for whose fault the payment of gratuity was not made to the petitioner. The question of payment of interest can at best be fastened upon the concerned respondent who has caused the delay. Respondent number 4 being a minority institution and petitioner being an employee of respondent number 4. Aided minority institution, right? The learned counsel for the respondent Ranchi University and State of Jharkhand are directed to seek instructions and file a counter affidavit in the present case.
I contradicted in it.
Who are you?
State.
So why are you unnecessarily disturbing? You have filed it?
Not.
Already filed?
Not sir.
You have addressed this point?
In that, they have stated that they have released the amount for.
That does not serve a purpose. You file a supplementary counter affidavit. Though, SLK, the learned counsel for the university is directed to seek instructions and file a counter affidavit. The learned counsel for the state counter affidavit has been filed by the state, but the point involved in the present case as to the liability of payment of interest on gratuity has not been addressed in the counter affidavit. Therefore, the counsel for the state is directed to seek instructions and file a supplementary counter affidavit. Issue notice to respondent number 4 under speed post. Thus, in addition, the requisites be filed within a period of by day after tomorrow or same date. You have taken the previous dictation, I suppose. Since common issue are involved in WPS number 5802 and the present case, let both the cases be tagged and heard together. I have given a date on 28th of February. You can have a look at this judgment of Supreme Court. I do not know whether you work out or not. This is Civil Appeal number 5118 of 2009, which deals with the payment of interest.
I also am relying on 2 judgments on the next one.
No, you give the judgment. Let them respond to it. दोनों में लिखिएगा. The learned counsel for the petitioner has relied upon following 2 judgments. बताइए.
Leadership 1 is 2014.
2014.
Volume 8 Supreme Court cases 894.
894.
And leadership 1 is of a Gujarat High Court judgment which has relied that judgment and stated that it is mandatory in nature and it cannot be.
The learned counsel for the petitioner has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2014 bracket close 8 SCC 894 and submits that this judgment has been followed by Honorable Gujarat High Court in
2022 SCC online Gujarat 575.
Please give it in writing also. 2022 SCC online Gujarat
575.
575. You provide a copy to the other side also. A recent judgment of the Honorables, this is 2009, old one. Anyways, let it be kept on record.
Yes.
Item 3.
Yeah, these, keep these things.
Item 3, WPS 5834 of 2023.
Your Lordship, the judgment yesterday you were referring was not uploaded till morning.
It has been uploaded.
WPC 3 of 23 was the judgment.
It has been uploaded by now. It has been uploaded?
Could not properly be copied.
देखिए तो 3 of 23.
3 of 23. Even I'm searched it right now.
5 to 24.
अपलोड नहीं हुआ है.
अरे हम बोले थे इसको अपलोड करने के लिए. Who is the सौरभ. ये ऑर्डर साइन हो गया तो अपलोड हो जाना चाहिए. Anyways, what is your case? You can have a look at it.
Yes, sir.
We'll give a short date to file a counter affidavit and figure it out as to what is the status of your claim for promotion.
That will
Should
suffice the
suffice.
purpose.
Then we can pass appropriate action. देखिए, the counsel for the petitioner is present. Nobody appears on behalf of the petitioners is present. Nobody appears on behalf of the respondents. The grievance of the petitioner is that the policy framed by the state of Jharkhand as contained in 4th April 2014, as contained in Gazette notification dated 4th April 2014, to convene the meeting of Departmental Promotion Committee twice a year is not being followed by the respondent, and therefore the claim of the petitioners for promotion is not being considered. He submits that the petitioners are entitled for consideration for promotion and they are nearly on the verge of superannuation. Let a counter affidavit be filed by the respondents. Which department is this?
This is. This is Water Resource Department.
Let a counter affidavit be filed by the respondents.
Respondent number 2.
Respondent number 2 will file the counter.
Yes, because respondent number 3 is Secretary Department of Personnel, only because I'm relying on their notifications for
All
that.
right. Let the counter affidavit be filed by the respondent number 2 by 15th of February 2024. Post this case on 19th of February 2024. Are you there for the state? The counsel for the state is present. You file your counter affidavit by 15th. Don't ask longer time. You just tell us that what is the stage of their consideration for promotion.
This direction will suffice my purpose if they consider.
That is why I have given a very short date. I want to have a look at the contract.
Public.
Item 4 WPS 6109 of 2023.
This petitioner.
This petitioner has moved this onto the court before also, Your Lordship, for the same thing, for his retirement use, Your Lordship. He was appointed under the services of Mental Area Development Authority and was working as a Khalasi, Your Lordship. He is superannuated in 31.
Where is your last order? You had moved earlier.
Yes, Your Lordship.
So what happened thereafter?
Your Ladyship, a direction was given to take a decision, Your Ladyship, and then they were paid.
Where is that order?
Your Ladyship, that is not a record, Your Lordship.
What is the case number?
Your Ladyship, it is WPC 338 of
WPC
2000. Yes, Your Lordship.
338 of
2009.
2009. Where have you mentioned?
Your Ladyship, I mentioned it in para 6, Your Ladyship. Page 10.
Where is the recent order?
Your Ladyship, that is also not on record, Your Lordship.
And you are seeking a direction.
Your Ladyship, after the recent order, I was paid 5 lakhs and 95.
Where is the recent order?
Your Ladyship, that is not on record, Your Ladyship. I was paid half of the amount, Your Ladyship, and after that, as some money was still due, I just filed representations, Your Ladyship. That is Annexure 1 series.
You have not even annexed a copy of the recent order. What kind of writ petition have you filed? If they have denied any of your claim under the recent order, they will not consider it.
Your Ladyship,
I will observe that, I'll dispose of the writ petition, but if any of the claim has been denied in the recent order which you have not annexed, they will not consider it.
Your Ladyship, they've not mentioned these heads only, Your Ladyship.
That is
Like
one
they
thing
can
that they have
cancel
not
it.
considered. But if any claim has been rejected in the recent order, then your claim will not be considered. Right?
That is fine, Your Ladyship.
WPS number 6109 of 2023, heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner at the outset has submitted that the petitioner had moved earlier before this court in WPC number 338 of 2009, which was disposed of by the order dated 1/1/2009, asking the respondents to take a decision. She submits that though a copy of the order has not been annexed along with the writ petition, but such statement has been made in paragraph number 6 and 7 of the writ petition. She has also submitted that a recent order was passed as mentioned in paragraph 8 of the writ petition, but certain benefits, the benefits as prayed for in this writ petition has not been considered. The said reasoned order, which has been mentioned in paragraph 8 of the writ petition, has also not been annexed along with the writ petition. At this, the learned counsel for the petitioner has submitted that if any of the claim which is involved in the present case has neither been considered nor been rejected in the recent order, then the respondents may take a decision in the matter so that the legitimate right of the petitioner to
May I make one submission?
what is this ACP you are claiming?
Lordship,
ACP you are claiming?
May I make?
This is not retirement benefits exclusively.
Lordship, may I
You
make
file your
submission?
counter.
All right. But it can be also disposed of, as the case is that he has got the retirement benefit. His claim is that some amount, and under some head, he has got lesser amount. So, he
You
is.
find it out. You can dispose of this
Lordship,
representation. But if any amount has been rejected in the earlier recent order,
That is not the case, Lordship. Case is simply that he has been paid under all the heads. But as per his calculation, lesser amount has been paid. So he is claiming that additional amount has to be paid under various rates.
But the reasoned order has also not been annexed along with the petition. The learned counsel for the respondents has submitted that it appears that the petitioner is aggrieved by calculation of the retirement benefits and other benefits which has been paid to the petitioner. The learned counsel has also submitted that if any part of the claim involved in the present case has been rejected in the reasoned order, there is no question of its reconsideration. But if there is any calculation error, or in case there is any other entitlement of the petitioner, the same can be considered by the respondents. The concerned respondent would be respondent number?
Respondent number 3, Lordship Secretary.
Respondent number 3 is the accounts
Yes,
officer.
two Lordship. Respondent number 2.
By the authority, namely respondent number 2.
Lordship.
Considering the aforesaid submissions made by the learned counsel for the parties, it appears that the petitioner had moved earlier in connection with payment of post-retirement benefits and other dues, and in WPC number 338 of 2009, which was disposed of on 1/1/2009, and a reasoned order was also passed. But the petitioner is claiming that there has been certain calculation errors in the matter of grant of benefit to the petitioner arising out of the reasoned order. In such circumstances, this petition is disposed of, enabling the petitioner to approach the respondent number 2 by filing a representation giving the details of the amount which has been already paid to the petitioner, and annexing a copy of the reasoned order which was passed earlier in the case of the petitioner. And upon such representation, the respondent number 2 shall seek instructions from the respondent number 3, the accounts officer, so that if there is any payable, any legitimate dues of the petitioner, the same be also paid. The respondent number 2 shall pass a reasoned order which, with regard to each and every item of the claim of the petitioner, as has been prayed for in the present petition. It is made clear that if any claim of the petitioner has been rejected in the reasoned order passed earlier, there is no question of reconsideration of such a claim. The needful be done by the respondent number 2 within a period of 3 months from the date of receipt of the representation. After giving an opportunity of hearing to the petitioner, the reasoned order be communicated to the petitioner through speed post, and if any amount is found admissible and payable, the same be also remitted to the petitioner within a period of 3 months from the date of the reasoned order. This petition is accordingly disposed of.
Okay. Item 5 WPS 6133 of 2023.
May I please, Lordship, this is a matter of promotion from sub-inspector to inspector.
Your name has been sent.
Yes, Your Lordship. The consideration was also being nominated, and on the date of the selection committee, where the promotion was being granted to all the other selected members, on the same day his consideration was also sent to the selection board. However, without considering his nomination from the concerning department, that is respondent number 5, the list of selected candidates were promoted to the inspector, leaving behind this particular petitioner, Your Lordship.
You just have a look at page number 41.
41.
जिसमें मेरी वरीयता क्रमांक 744 को क्या बोलते हैं?
That is the representation being sent.
Yes, yes, it is your representation.
Yes.
Have a look at it.
क्रमांक 744 था मैम।
हाँ, आगे
परंतु
परंतु
मेरा सेवा संपुष्टि नहीं होने के कारण उक्त बैठक में मुझे अयोग्य ठहराया गया
that's
था।
right. So your services were not confirmed by them.
Yes, ma'am. But on the date of promotion, that is the memo number annexure 1, ma'am. If you could kindly, Your Lordship, kindly produce annexure number 1, ma'am. Starting from the first line, ma'am. उपयुक्त विषय के संबंध में कहना है कि पुलिस अवर निरीक्षक से पुलिस निरीक्षक की कोटि में प्रोन्नति पर विचारण हेतु दिनांक 27-28-5-2020 को संपन्न महानिदेशक चयन परिषद की बैठक का वृत्त अग्रतर कार्रवाई हेतु संलग्न की जा रही है। संलग्न सूची में योग्य घोषित पुलिस अवर निरीक्षकों को प्रोन्नति हेतु आयोजित बैठक की तिथि के पूर्व यदि कोई विधि का प्रारंभ की गई हो अथवा विधिक दंड पारित किया गया हो अथवा आपराधिक कांड में आरोपित हो अथवा किसी न्यायालय में कोई मामला लंबित हो तो उसकी सूचना अविलंब
You see, unless you see, annexure 4 is itself indicating the reason for non-consideration of it.
Yes, ma'am. The consideration letter, if you Lordship may kindly peruse annexure, my annexure. Annexure 2, ma'am. Page number 39, ma'am.
Yes. Is there any reason your matter was not placed before the authority?
The matter was placed. The matter was sent to the concerning respondent number 3, ma'am. On the same date when the selection committee formed and promotion were being granted.
When? What is the date, please?
The date is 27/28/5/2020.
5.
27/28/5/2020.
Right.
That was.
On this day, your services were confirmed?
Yes, ma'am. Annexure 2, ma'am.
Annexure 2. What
Yes,
is the
ma'am.
date?
28/5/2020.
It is one day after.
On the same date, ma'am.
No,
27/28/25/2020.
So it was on the same day, therefore your matter could not have been placed. Now you want that your matter can be placed before then.
Yes, ma'am. That matter was already being placed through my representations, ma'am.
That's right.
That on the day of
Now
selection.
they have said that it has already been forwarded.
The respondent number 5 is referring to the same annexures which I have annexed in this petition. That they have sent the consideration letter to respondent number 3. Now it was the respondent number 3.
It has been sent on 18/6/2020.
No, ma'am. Annexure 2.
You just come to para 11 of the counter affidavit. It has been sent on 18/6/2020.
Annexure B to be more specific.
Yes, it has been sent on 18/6/2020.
18/6/2020, ma'am. Ma'am, if you could kindly consider my annexure 2, ma'am. That
I have
was
seen
from
your
the same-
annexure. It is on the same day. Therefore,
was on the
therefore
same
it
day,
could not have been placed. Rightly
Yes,
so,
ma'am.
right?
Right.
Because there has to be a recommendation from the place wherever you are posted, and then only it will be taken into consideration.
However, yes, ma'am. On the same day it reached
That's
to
right.
the concerning department. Unfortunately, that
That's
cannot be
now
placed.
there is a fresh recommendation. It can, now your juniors have been promoted.
Promoted.
There must be more promotional posts available.
But regarding that, we have not received any instruction of that. But I was just submitting that on 18/6/2020, since the recommendation has already been sent.
That will be placed.
Again, a fresh
is-
recommendation.
It is not a fresh recommendation. Actually, your services were not confirmed, and it stood confirmed only on 28/5/2020.
Ma'am, there was another paragraph on annexure 1, ma'am, whose services were not being confirmed or consideration was not being forwarded to the concerning department. 14 days was given. So within 14 days, the consideration or letter was to be received by this department, and thereafter it needs to be considered.
So
So
now they have
within that
sent
14
it.
days, within that 14 days, my consideration was.
So now they will
available
have to
with the-
consider. You see, there is no private party involved in this case.
Yes.
So we are not going to mention about any juniors promoted, and that grievance we cannot say. But the point is that in the counter affidavit, the matter has now been recommended. Now it will be considered in the departmental promotion committee whenever it is taken up.
Ma'am, the petitioner needs to be promoted from the same selection committee date, ma'am. Because, ma'am, at the time, because
We do not know. That is a separate cause of action. What effective date they will give you, we do not know.
Ma'am, if you
There is no,
kindly
you
consider.
see, just a moment. If your juniors have been promoted and you have not been promoted, so now they will have to push back. None of the private party is there in this case. We do not know.
Ma'am, to the best of my knowledge, ma'am, though I have not
Your
received
knowledge,
it.
you just tell us, can we disturb the promoted position of any person without making him a party before this court?
Ma'am, the respondent number 3 has promoted several juniors even after
But those
selection
juniors are
committee.
not before us.
Ma'am, even
Therefore,
the last
just a moment,
2023,
please,
ma'am.
please hold on.
Yes.
Let your promotion be considered and let us see what quota, what date they gave, what effect they give. We do not know. If you make a grievance that your junior has been promoted and you have been left out, then you have to make the juniors also party,
No,
no?
no, ma'am, I'm not concentrating on my grievance that the juniors have been promoted instead of me. Ma'am, my only grievance is my consideration was considered to be from the selection board because I had completed my service in the year 2016.
By
But
completion of service, you get promoted?
No, ma'am. But since the
Automatically?
committee could not be formed, committee formed in the year 2020, and on the same day when the promotion were given, and also 14 days
So,
were being granted
that's
to the candidates whose consideration has not been received. So within that 14 days, my consideration was received in the to the respondent number 3, and even after that, the others. Within 14 days, whose consideration got received by the respondent number 3, they got promoted accordingly. And recently in the year 2023 also they have published a recent list
we
of
cannot
candidates.
pronounce on, what date, what cutoff date they will give. We will not pronounce on that because they have not yet taken a decision on your promotion.
At least they should consider
They
the
will
same
consider as per
consideration
the
of-
counter affidavit it has been placed.
Yes, it is for the respondent
Right.
number 3 to
Yes.
take action on that.
You place it on the next departmental
Yes, yes.
promotion committee whenever it is held because there is already a recommendation
Yes,
and you do it.
yes,
Ma'am,
that can.
ma'am, Your Lordship, ma'am, Your Lordship. Your Lordship, so far as the next selection committee going to be conducted, that is not definite when the selection board
We
is going to-
we cannot set aside the selection which has already been made.
No,
That
we
is
are-
not the subject matter of consideration in this case.
No, I'm not. I'm not pressurizing on the setting
So
aside
what do
of
you
the
want? You just
consideration
read your relief. You just read. You are seeking a mandamus. We are giving a mandamus. That's it. You are seeking a mandamus. We are issuing a mandamus. Isn't it? Tell us.
When in the future, when the selection board, however, my prayer was confined.
Your
to-
prayer is confined to whatever relief you have prayed for. Nothing beyond. You cannot change your relief by arguments. लिखिए, learned counsel for the parties are present. This petition has been filed for the following relief.
Your Lordship,
The learned
kindly
counsel for the
ask-
petitioner has submitted that the matter matter relates to promotion of the petitioner to the post of inspector. It is a grievance of the petitioner that selection that the meeting of departmental promotion committee was held on 28/5/2020, but the case of the petitioner could not be taken up as the petitioner was confirmed, but the petitioner was confirmed in service on 28/5/2020 itself. The learned counsel has also submitted that those persons whose services were not confirmed, the departmental promotion committee had granted time so that appropriate decision is taken. Time of 14 days.
14 days के अंदर पुलिस मुख्यालय को अवगत कराया
हाँ,
जाए ताकि पूरक चयन पर्षद
That's right.
विचारक मामला रखा जा सके.
14 days was granted so that the matter could be taken up. The learned counsel submits that the services of the petitioner was confirmed on 28/5/2020, but the case of the petitioner has been left out from consideration. And therefore, he is seeking promotion with effect from the date where he is seeking a mandamus from this court with effect from the date when his juniors were granted promotion. The learned counsel for the respondents, on the other hand, has submitted that a counter affidavit has been filed by respondent number 5, stating that the petitioner
Para 9 page 11.
just a moment. Stating that by memo dated 15/6/2020, the respondent number 5 had forwarded supplementary nomination of the petitioner for promotion to the post of Inspector of Police from Sub-Inspector of Police to the Deputy Inspector General of Police, Palamu Range. And subsequent thereto on 18/6/2020, a meeting of Supplementary Regional Selection Board, Palamu, was held in the chairmanship of Inspector General of Police, South Chotanagpur, Palamu Range, Daltonganj, in which the petitioner was found suitable for promotion to the post of Inspector, and accordingly by letter dated 18/6/2020, the Deputy Inspector General of Police, Palamu Range, has forwarded the recommendation of the petitioner to the Deputy Inspector General of Police, Jharkhand, Ranchi. It appears that the necessary formalities in connection with the promotion of the petitioner has been done at the end of the respondents, but there has been some delay, and consequently junior to the petitioner has been promoted and the petitioner has been left out. This court is of the considered view that the matter is required to be considered by whom?
By respondent number 3.
Is required to be considered by respondent number 3.
DIG Palamu area.
Respondent number 3, no?
Yes. Deputy Inspector General of Police Personnel, Jharkhand.
Okay. The matter is required to be considered by respondent number 3, who shall also take into consideration that the petitioner should not suffer for any laches or delay on the part of the respondents in the matter of sending the requisite documents for promotion of the petitioner. He shall also take into consideration that as per the case of the petitioner, his juniors have been promoted and he has been left out.
Which will also may kindly produce Annexure 3 also.
Why do you disturb so much? I'm giving you enough. I'm giving you more than what you have claimed in your writ petition. Accordingly, this writ petition is disposed of, enabling the petitioner to approach the respondent number 3 by filing a representation and also a copy of the records of this case, and point out in the representation regarding the names of the juniors who have been promoted prior to the petitioner and the petitioner has been left out. The grievance of the petitioner will be taken care of by the respondent number 3, who shall pass appropriate orders in connection with the claim of promotion of the petitioner within a period of 6 weeks. 6 weeks will be longer, within a period of 1 month from the date of representation. That should suffice. You can also give him notionally from such and such date. Maybe financial benefits you can give from a later date. That should be done. He should not suffer for your laches. This petition is accordingly disposed of with the aforesaid observations and directions. The reasoned order be communicated to the petitioner who is proposed. You give specific names of the juniors, which is missing in your petition. Totally.
Item 6, WPS 6272 of 2023.
Yes, petitioner.
The petitioner was working as an assistant teacher in government aided minority school. His appointment was done
Your,
in the, yes,
you
sir.
have a remedy under tribunal?
Your Lordship, my grievance is against the state government.
So,
It is not against the school. So the JET will not have the jurisdiction.
what is your grievance? It is a aided minority institution. You are not mentioned anywhere. We are not
Government
able to
aided
find it
minority
out.
institution. It has been mentioned.
Where is it? Where is it mentioned that this respondent is an aided minority institution?
There was one sanctioned post. Against that post, I was appointed.
Where is your appointment letter? All the formalities were followed, advertisement, etc. done.
Paragraph 14, Your Lordship, we have stated
What para 14 you have stated? What?
that it is states
It is
and
a general
summaries.
statement.
Yes. Annexure 2 is my appointment letter
Who has
by
issued
the
it?
school management committee.
Where is the advertisement? In the minority institution,
Yes.
against a sanctioned vacant post, it has to be through advertisement. Where is the advertisement?
Advertisement is not on record.
Then we can't issue such a direction.
I made a representation before
No.
the DSC. They can, because admittedly I have worked for
That
10 years.
doesn't work out. For a minority institution,
Yes, Your Lordship.
against vacant sanctioned post, there has to be an advertisement, as I understand, isn't it?
Your Ladyship, they say they have worked for 10 years. In
That
the
is not
petition.
sufficient. I will not issue any mandamus. You
Can
can
we-
withdraw and pursue your remedies, whatever you have.
They may take a decision on my
No,
representation, Your Lordship.
no, I am not satisfied. Especially, I am not satisfied. You
Admittedly-
show me that you could have been appointed in any manner without advertisement against vacant sanction post in a minority institution.
There is a document, Your Lordship,
Document,
that I have not brought on record.
yes.
The attendance register.
That is not sufficient.
In that it has been
In a,
clearly.
you just tell us.
Yes, sir.
You go and talk to your senior. That
Yes.
in a minority aided institution,
That has to be.
there has to be an advertisement. There is no advertisement.
Second time they have issued the advertisement for the
That
same
you
post.
participate, we do not know.
That she has participated also.
And successful.
Her name is in the list, Your Lordship,
We
provisional
can't
list.
do anything.
Your Lordship, they can take a decision on my representation.
No.
For the release
No,
of the
no, no.
salary also.
No.
Because
For against minority institution, we will not issue any direction for release of salary if you are working against appointment made by the minority institution and not against vacant sanction post. So your relief is not against the state. You come in the second half, we will not issue mandamus like this.
annexure 2, Your Lordship.
You pursue your remedies, that would be better. Otherwise, I will simply say that
Can
you
we
have
see
not
the
been
annexure 2, Your Lordship?
annexed.
The appointment by the school management committee.
That is a relief against private management committee, not against the state.
Because state has
This
to
is
come.
after advertisement. Annexure 2 is after advertisement.
Vidyalaya, annexure 2, page 24.
Show me the advertisement. Show me the selection process.
आज दिनांक 7/8/2014
That
को
doesn't serve a purpose.
in minorities institution, the school
You see,
management
in
has to.
minority institution, there are two kinds of appointments.
Yes,
One is through advertisement against vacant sanction post,
yes, sir.
and other is they can otherwise appoint anybody they want to. That is a separate thing. But merely because somebody has been appointed by them,
Yes.
that does not confer a right of regularization or adjustment against vacant sanction
Definitely,
post.
but for salary, they can be entitled, Your
No,
Lordship.
not from the state.
The state has to release the fund.
No, you are not. You see, do you know, or you want to be sure? You want to be ignorant about it. You call your senior. You do not know the law. Come in the second half. You do not know the law. You come in the second half. Call your senior. He knows it quite well.
From the daily list, under heading for orders, item 7, WPS 3024 of 2003.
Yes, petitioner.
I'm
Don't
for
be
respondent-
absent in the second half, otherwise I'll dismiss the case.
I'm for private respondent number 6, please.
Yes?
Petitioner has challenged the order of dismissal from service.
You file your counter. Have you filed?
Well, it's on the last date, there was a direction to seek instruction. There was an answer. The case is that
I've seen it. There is an answer.
subsequently answer a
You have-
supplementary is there. I couldn't file because it has been affidavit to
Alright.
court
Who has been
yesterday.
appointed?
No one has been appointed. That has been cancelled.
Okay, that has
There is
been.
a clear-cut direction to appoint the private respondent number 6 because she was having higher education qualification.
Okay.
And as per the rules, the person who is having the higher education qualification and who is the resident and Sthaniya Bahu,
That's right.
that person is entitled for appointment.
So that selection process is cancelled?
No, ma'am. It's still active. That has not been cancelled. Moreover, there is a
No, there was an Aam Sabha, no?
yes,
What
that has
happened
been
in
concluded, and wrongly the petitioner has been selected. And after her selection, that was challenged before the Honorable High Court. There was a direction to approach the concerned DC, and after approaching the DC has passed the order. Kindly,
Where is you have not even filed your affidavit and you want to argue?
it's just one annexure, madam. Annexure 2 with the
No,
petitioner.
you
has been
want to
accepted.
file your affidavit or you don't want to file your affidavit?
I'll file it.
It's ready for filing.
No, it's not ready.
You're for the private respondent number 6?
Yes. Annexure 2 is to be seen. That's just last paragraph.
You can't have it like this. Either you file your affidavit or you don't file it. You say that you don't want to file it.
I don't want to file it.
You don't want to file an affidavit? So in the Aam Sabha election, what happened? We do not know. There is a direction to bring on record what happened in Aam Sabha.
In Aam Sabha election, the petitioner was appointed.
You see, accordingly, learned counsel for the petitioner as well as respondent members are directed to seek instruction as to whether decision was taken by the Aam Sabha in the same.
That has not been taken. A subsequent Aam Sabha was conducted.
When was it?
Reverse the rules. Why I am saying that, Malak? Because
see-
annexure 2 is to be seen.
Whatever you are saying, is it something which is born out of record?
Yes, ma'am.
That there is a subsequent Aam Sabha
Yes, that is born out of the
after 24/1/2024?
on 24/1/2024. There was
So
Aam
that
Sabha.
is why I want to know on 24/1/2024
A
what
supplementary
happened.
was to be filed, Malak. It's ready. I couldn't file because it was affidavit yesterday itself.
Mr. Counsel, you just tell us on 24/1/2024 nobody was selected.
No,
According
it
to
was
you.
cancelled.
There was another Aam Sabha.
No,
Nothing.
No.
It has been cancelled.
yes.
Bring it. You just file it right now.
Yes, I'll do that.
You file it right now across the board. You have given it to the petitioner?
Yes, I've given to the respondent seat also. Paragraph 3 of that affidavit.
So the case becomes infructuous. How? Let us see.
Annexure,
There is a direction to cancel the appointment of the petitioner.
yes. Annexure 2 is annexure 3 is to be seen first, Madam, which is annexed with the writ petition at page 30.
Yes.
There was a Aam Sabha conducted on 5/4/2022, and even the petitioner and the private respondent 6 were the participant to that Aam Sabha for selection of Anganwadi Sevika and Sahika to the post of Anganwadi Sevika and Sahika. In that Anganwadi Sevika and Sahika, in that Aam Sabha manner, the petitioner was selected, though she was having a lesser qualification than the present petitioner, respondent number 6. Respondent number 6 appeared before the Honorable High Court in WPS number 5132 of 2022. There was an observation of the direction of the Honorable High Court that the petitioner, that is private respondent 6, to approach before the concerned DC, and DC will take a final decision on that. Manits, Annexure 4 is the order of the DC. I'll just read the operative part
This
of
order
it.
is under challenge.
Yes, this is under challenge.
Let us see.
May I read the operative part?
Yes.
Page 32 onwards, the last paragraph. आवेदिका का कागजात एवं जिला समाज कल्याण पदाधिकारी समर्पित दस्तावेज का अवलोकन किया, जिसमें दिनांक 5/4/2022 को संपन्न सहायिका पद का चयन से संबंधित कार्रवाई की छायाप्रति से स्पष्ट होता है कि आवेदिका का शैक्षिक योग्यता सभी अभ्यर्थियों की शैक्षिक योग्यता से उच्च योग्यता है। आवेदिका ने अपना मायका जिला औरंगाबाद बिहार का जाति
This
प्रमाण
Avidika is respond number 6.
Yes.
Continue please.
आवेदिका ने अपना मायका जिला औरंगाबाद बिहार जाति का प्रमाण पत्र समर्पित किया था, जिसे अमान्य कर दिया। आवेदिका शादी के उपरांत स्थानीय बहू है। स्थानीय बहू एवं जाति का उल्लेख कार्रवाई प्रपत्र दिनांक सच में उल्लेखित है। यह स्पष्ट है कि महिला का जाति प्रमाण पत्र उसके खतियानी पैतृक निवास स्थान से निर्गत होता है, जिसे अमान्य कर देना नियमानुकूल नहीं है। आवेदिका सहायिका पद पर चयन योग्य है। ऐसी स्थिति में जिला समाज कल्याण पदाधिकारी पलामू को निर्देश दिया जाता है कि दिनांक 5/4/2022 को संपन्न आम सभा में कम योग्यताधारी श्रीमती मीना कुमारी, दैट इज द प्रेजेंट पिटिशनर, पति अशोक रजक का नियुक्ति रद्द करने के संबंधी आवश्यक कार्रवाई करते हुए उच्च योग्यताधारी आवेदिका ज्योति कुमारी को नियमानुसार चयन करना सुनिश्चित करें।
Who has cancelled your caste certificate? Who has cancelled your caste certificate and where is the order of cancellation?
There is no such order. There is no such order.
But this order is saying that your caste certificate was cancelled. Amanya means not accepted.
They have not accepted. And henceforth, Meena Kumari, the present petition was appointed. That was challenged for this order.
Yes, madam. The matter ends.
So your show was in court. If your Lordship will turn to Annexure 3, page 30, if your Lordship. Page 30, your Lordship. Earlier, respondent number 6, your Lordship.
We have heard all that. You were not there.
Yes, your Lordship. If your Lordship will turn to the rule Annexure 5, page 33. Page 33, your Lordship. The relevant portion is page 38. Yes, your Lordship.
Page 30?
38. Page 38.
Yes.
फर्स्ट पैराग्राफ, फोर्थ लाइन फ्रॉम द बॉटम। झारखंड में आरक्षण की सुविधा नहीं मिलेगी। इसी प्रकार यदि कोई महिला
No, no. Which one? Which
पेज
paragraph?
38 your lordship, first paragraph, fourth line from the top, from the bottom.
Okay.
Has your lordship? यदि इस प्रकार यदि कोई महिला विवाह के आधार पर किसी अन्य राज्य से झारखंड में अवराजित होती है, तो ऐसी महिला को अनुमान्य आरक्षण की सुविधा उनके मूल राज्य में उपलब्ध नहीं होगी। And thereafter, if your lordship will see annexure 4,
मूल राज्य में उपलब्ध नहीं होगी मतलब?
उपलब्ध नहीं होगी your lordship. There is a reservation category which says that the lady.
What is मूल राज्य?
मूल राज्य your lordship, the parent.
She belongs to Aurangabad,
She belongs to Bihar.
So she will not be entitled for reservation
in Jharkhand.
No, in Bihar.
No, your lordship.
मूल राज्य में उपलब्ध नहीं।
मूल राज्य is Jharkhand, your lordship. What they say, the rule says your lordship is that.
Just translate this. Do you want to say that if a reserved category candidate gets married in Jharkhand, she will not be entitled to
Yes,
pay
sir.
reservation?
The rule says so.
Just a moment. The bahu will always come from other state or other place.
Lord.
Bahu will always come from other place, isn't it?
Yes.
Then
But your lordship will see that the honorable court of this court has also passed an order which says that after marriage the reservation will not apply to them.
after marriage, the girl will not get reservation.
Yes, sir.
But bahu will get the reservation because she comes to the village.
But your lordship, she can get reservation in the state where her parental home is there, not in the state after where she has got married. But that's the rule which says.
You see, when you talk about bahu,
Yes, sir.
daughter-in-law,
Daughter-in-law.
she has to come from other place. She has to come from other place, isn't it?
She'll come. But your lordship, the rule itself, the order, if your lordship will see the order
You
also.
just tell us common sense. This daughter-in-law will certainly come from other place, isn't it?
Yes, Your Lordship.
Then, what is her caste?
SC.
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 She must be SC in Bihar also.
Yes,
in
Your Lordship.
Jharkhand also.
Yes, Your
It
Lordship.
is not a case that in Jharkhand she is not SC. She is the Bahu in Jharkhand, not in dispute. So,
Only by 2 points of argument before Your Lordship will be, Your Lordship, that in Annexure 4, if Your Lordship will see, after the respondent number 6 moved to the Honorable High Court, the Honorable High Court directed her, the DC, to take a decision. Annexure 4, if Your Lordship will see for a moment.
yes.
Without, I was appointed as a armed sevika, Your Lordship. Without me being heard, Your Lordship, the DC terminated my order.
No, now we are hearing you.
Yes.
Now you tell us that how are you prejudiced by this order and what is your ground?
My only ground is, Your Lordship, 2 grounds of which I am, Your Lordship, that one, the DC did not hear me and has terminated me.
Yes. What else?
And the second rule which I had placed before Your Lordship is that the person has to belong from the state, and after marriage she cannot come and claim in the state of Jharkhand that reservation here, which the
So
Honorable High Court, if
therefore
Your
I
Lordship, para 8 if Your Lordship will see, para 8 of this chapter.
This was regarding this interpretation of this rule only.
Interpretation of the rule which says that Your Lordship, reservation cannot be.
You see, you are governed by this rule. Is it an interpretation of this rule?
No, Your Lordship, it's not an interpretation of
It
the
is a general rule.
It's a general.
Right, that the person who is having reservation outside the state will not be entitled for reservation in Jharkhand. That is a separate thing altogether. But when you are giving certain benefit and certain things which are reserved for the daughter-in-law of the village, then under such circumstances, how do you deny her caste and deprive her of reservation? Because daughter-in-law will certainly come from other place.
Yes, Your Lordship.
Then,
but the rule which was made.
daughter-in-law, that is why I want to know that are these judgments relating to the rules regarding Anganwadi Sevika?
No. For our.
No.
It's not there, but Your Lordship, the parent. But the rule, if Your Lordship will see annexure 5 for a.
You
because
translate
the
this.
rule is,
You
Your Lordship, the rule
read
is not.
clause 10, please. You read clause 10 fully.
Clause changes. From page 37 it starts.
Yes.
आवर्जित श्रेणी के अनुसूची, अनुसूचित जाति, अनुसूचित जनजाति एवं केंद्रीय अन्य पिछड़ा वर्ग के सदस्यों के जाति प्रमाण पत्र हेतु गृह मंत्रालय भारत सरकार के पत्रांक सचिव सच ST दिनांक 22/3/1997 एवं पत्रांक नेक्स्ट पेज पत्रांक सचिव सच एंड BCDI दिनांक 22/2/1985 तथा कल्याण मंत्रालय भारत सरकार के पत्रांक F19 सचिव सच दिनांक 8/4/1994 के प्रशासनिक है। इस अनुसार जाति प्रमाण पत्र निगृहित करने हेतु किसी व्यक्ति के किसी स्थान विशेष का होना महत्व रखता है। शिक्षा ग्रहण करने, आजीविका प्राप्त करने अथवा अन्य उद्देश्य से कई व्यक्ति दूसरे राज्य से आकर बस जाते हैं। ऐसे लोग आवर्जित श्रेणी माइग्रेट में आते हैं और इन्हें अनुमान्य आरक्षण की सुविधा इनके मूल राज्य में ही उपलब्ध होगी। झारखंड में आरक्षण की सुविधा नहीं मिलेगी। इसी प्रकार यदि कोई महिला विवाह के आधार पर किसी अन्य राज्य से झारखंड में अपराजित होती है तो ऐसी महिला को अनुमान्य आरक्षण की सुविधा उनके मूल राज्य इन विच इज अ पेरेंट मूल राज्य में ही उपलब्ध होगी। पैराटेनेसिस ऐसी अवरजित श्रेणी के व्यक्तियों
You
को
just tell us that in the case of SC/ST, the declaration is made by whom?
case of ST.
Who declares that a particular category will belong to SC or ST?
State.
Central government notification. It's a central government notification, as I understand. Is that so?
Yes. Though it's a central government notification, but
Yes,
the
Mr.
state-
Subhashish, you must be knowing. It's a central government notification. A central government notification declaring a particular caste to SC or ST. Can it be confined that the person who is declared SC and ST by state of Bihar will cease to be SC ST in the state of Jharkhand? Yes. It is not a state government notification. OBC is declared by the state government. SC and ST, particularly SC, is declared by the central government. And this particular community, what is her community, is common in state of Bihar and state of Jharkhand.
SC.
This she belongs to which community?
SC.
S.
SC community also.
Even the Anganwadi rules is very specific to that effect.
Let us see.
That has not been annexed. The rule clearly states that स्थानीय बहु होनी चाहिए, शैक्षिक योग्यता में सबसे उच्चतर होनी चाहिए. It clearly states all this.
Your Worship, it's just because she's been work for the state government, Your Worship. It's a job under state government. So the state government notification will prevail because it is
The
a
state government does not declare a person SC.
It doesn't declare SC.
Then state
but
government
then it's a state government notification which says that the persons who have been parental home which of the same state will get the reservation category and not those who have migrated for maybe from after the marriage or due to work reasons they have migrated or any other reasons. They will not hold it. Your Lordship, and my learned friend has also filed
Where
a
is the
judgment of
rules?
five-bench judgment, which says that the state person belonging to one state, ST or SC, cannot claim reservation in another state. Though I have not got it, I'm sorry, Your Lordship, but I'll get that judgment.
Well, Annexure 2 may be seen for a moment, page 29.
Yes, page
Now,
20.
yes, clause 2 of it, सेविका सहायिका का पद सरकारी नहीं है, मानदेय के रूप में सेविका की प्रतिमा 6400 रुपए तथा सहायिका का प्रतिमा इतना रुपए में दे होगा.
It is a contractual job. They are not government employee. Maybe that they are receiving money from the funds of the state, but they are not government employee.
And meanwhile, Your Lordship, we have also filed an IA application for because
That has become infructuous because no decision has been taken in that answer.
It had been cancelled last time, but I think as per my instruction in the last date, but as per my instruction, Your Lordship,
We do not know that nothing is on record. If you have been instructed, you have not put it on record.
But Your Lordship will appreciate that the DC without hearing me has had terminated me. She went to the High Court.
Now the only issue which crystallizes is whether the respondent number 6 can be granted reservation, can be considered under the reserved category candidate, being the daughter-in-law of the place, having her caste certificate issued from the state of Bihar. That is the only point. So that is a legal point.
Yes, that's a legal point.
So we are giving you hearing. What is the big idea of referring it back to them? When we are discussing so much, you think that those authorities will be in a position to answer this kind of a constitutional issue? Then you address, both of you address, where is the rules of Anganwadi Sevika? You have not annexed the rules.
That has not been annexed by the present petition.
You see, now the issue is very clear. You come with whatever judgments you have, right?
Yes, sir.
Mr. Subhashish, they are not in a position. I will appoint an amicus. I need assistance because this is not something which. So you assist this court in this matter. Can you get ready by tomorrow?
Yes.
Tomorrow it is not possible. We will post it on next Wednesday because tomorrow is criminal revision. You get the copy. We need the assistance, you see. You are not in a position because there is a recent judgment of the Honorable Supreme Court also, as I remember. I am not sure this issue was there. Whether a scheduled caste.
Versus Union of India.
Sorry?
Janit Abhiyar versus Union of India.
Says what?
It says that Your Lordship, the CST of one state cannot claim reservation in the another state. Though I have not got the.
Which is it a recent judgment?
Yes, Your Lordship. It's a. I'll get it in the next take. On the next take, I'll assist your lordship if we have.
As I remember, the judgment is otherwise. I don't know.
Yes, we'll
I have to
assist.
see that judgment.
We'll assist your lordship and with the.
Learned counsel for the parties are present. A supplementary affidavit has been brought on record stating that on Aam Sabha held on 24/1/2024, no decision has been taken. The solitary point involved in the present case is Anganwadi Sevika.
Yes.
After hearing the counsel for the parties, this court finds that the only point involved in the present case is as to whether the respondent number 6, who belongs to state of Bihar and is a scheduled caste category candidate, married in state of Jharkhand and is daughter-in-law in the concerned village, can claim the status of backward of scheduled caste for the purposes of her appointment as Anganwadi Sevika. It is not in dispute that respondent number 6 has more educational qualification than that of the petitioner, right?
Yes.
In order to considering the point involved in the present, the counsel for the considering the point involved in the present case, this court appoints Mr. Subhashish Soren as an amicus in the matter to assist this court on the legal point. The counsel for the party shall also advance their argument. State has filed a counter. Do you want to file any supplementary counter? The learned counsel for the parties have submitted that since the point is a legal point, they do not need it, they do not find it, they do not want to file any further counter affidavit in the present case. If you want to file it, you file it. Do you want or you don't want?
No, we don't want it.
Okay. The rules governing appointment of Anganwadi Sevika is not on record. The counsel for the state shall produce the same for consideration on the next date of hearing. Let a copy of the entire records of this case be provided to Mr. Subhashish Soren by the petitioner during the course of the day. Right? Post this case for further hearing on.
Even the copy of the rules may be provided to us.
Yes, you provide it, you'll get it. Right? It is in most of the Anganwadi case that is there. The learned counsel for the petition has relied upon judgment passed by this court in WPS number 3050 of 2019, decided on 13/12/2023, as well as yes. इसको जरा चेक करिए, इसमें अपील फाइल हुआ है. WPS 3050 of 2019. Any appeal filed?
No, that's from my understanding.
You get ready?
Indeed.
We are posting it on next Wednesday. Post this case on next Wednesday for further hearing. This is fresh filing?
No, it's not fresh filing. It's
Or-
not
or
orders.
it was running under orders since
IA was pending.
IA has become infructuous
Yes,
now?
it has.
IA number so and so having been rendered infructuous is closed. Right? Next Wednesday? It's a holiday. Next to next Wednesday.
Holiday.
Next to next Wednesday.
Oh, yes.
Right?
31.
I will just observe. In the meantime, if the if the parties want to file any supplementary affidavit on the aforesaid point involved in the present case, they may do so by next Thursday.
We'll also file because
You do
we have
whatever,
also
because it's a legal issue, you will decide.
instructions we have got that she has secured more marks. We have secured more marks than now. So I have asked for to get the records.
If you want to file any affidavit, you file.
That will take extra. Appeal file LPA file.
Next. Under appropriate heading.
Item 8 WPS 3119 of 2003.
Initially, the petitioner challenged on the seniority list, provisional seniority list, and except for page 59. Thereafter, the respondents came out with the final list and accepted.
They have not filed any counter
No,
affidavit
that
to
was the
your
direction.
amended writ petition. You filed your counter
Yes,
affidavit. Counsel for the parties are present. Counsel for the respondents pray for and is granted time till 28th of February 2024 to file a counter affidavit to the amended writ petition. 28th. 6th of March. Mr. Sani, your juniors have been promoted.
Another application.
Yes.
There are two applications were placed, one for amendment. Another one, they raise an objection that the petitioners are working under different JAPs, JAP 2, JAP 10. So they wanted that the commandant of respective JAPs should be made included as a party. For that reason, on the same day, I filed two petitions. One has been disposed of, that is amendment, which was allowed, but due to inadvertence on my part,
What is the IA number?
That is IA number 7526 of 2023.
7526.
7526 of 2023.
कहाँ है 7526?
The disposal part.
देखिए जरा disposal में 7526 आई है.
75 दोनों आए. See, then both have been disposed by the same one.
You need more time. 28th February is not sufficient. You need 6th of March.
Yes.
Right? Rejoinder by 13th.
Yes.
Post on 18th of March. Under the heading for admission. Is there right of any junior to you being
Yes.
affected?
That
They
is
are not
the-
party before this court.
Juniors have already been sent for training. That is on the original writ petition. That there are other posts also available to
Okay,
the
available.
post of inspector, so there is no clash between them.
Okay.
Only grievance not for in future also the petitioner shall suffer.
That's
Under heading for fresh filing, item 9 is wrongly listed. Item 10 WPS 1080 of 2023.
Yes, petitioner.
May I please read? Lord, the petitioner before leaderships were appointed as librarians in various divisional libraries in the district of Hazaribagh. They prayed, my lord, that the areas for the revised pay scale may be paid to them, as because the similarly situated person, my lord, approached this honorable court in the year 2004 itself, my lord, and by virtue of the judgment dated 5/12/2008, that is Srimati Premlata Sinha, that the matter was set at rest and the direction was given to the state of Jharkhand to make the payment, because even the non-government aided institutions are entitled for the revised pay scale. Subsequently, the state moved for the review of that order. Thereafter, LPA was preferred, and subsequently, the Honorable Apex Court has upheld this judgment.
So why have they not given you? You have filed some representation.
Yes, certainly. I have filed representation, that is Annexure 8 series. And even the state of Jharkhand has taken a decision, that is on Annexure 7. Lordship may kindly consider that the revised pay scale along with the DRN's allowance from the year 1997 is to be paid to this, with all the librarians who are posted.
So where is your representation?
It's Annexure 8 series 53 page.
53. Is your representation?
Representation. Altogether 4 petitioners are there.
You before whom have you filed? Respondent number?
Respondent number 4, the director.
Respondent number 4.
And furthermore, leadership, similar situated case, the leadership has considered, I may be permitted to forward a copy. Same issue was involved in this matter as well.
Similar order can be
Similar
passed.
order. Only, my lord, that in this case, the direction was given to the respondent number 4, that was DC in that case.
Okay,
But
now-
in my case, it's the director. I haven't
Director.
completed the DC.
That is respond number, here
Four.
also respond number 4 only?
Four.
Okay, so this respondent is okay, right?
Yes. There annexure 9, that is the.
Whom will he consult? In
his-
consultation with?
Five.
Respond number 5. So respondent numbers is not a problem.
Mm.
And you have been representing before whom?
To respondent number 4, that is the director.
Okay. You have been working as librarian in the district of?
Hazaribagh.
District Central Library?
Divisional library.
District Divisional Library.
Divisional library.
And your representations are contained at
In
annexure?
annexure 8 series.
Annexure 8 series. लिखिए. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioners have been working as librarian in the District Divisional Library, Hazaribagh.
Divisional libraries in the district of
Divisional Library in the district of Hazaribagh. He submits that the petitioner is entitled for the relief as prayed for in the writ petition, and basically the resolution dated 27/10/2020 is required to be implemented by the respondents, and as per the said decision, the petitioners are entitled for dearness allowance notionally since 1996 and financially since 1997. The learned counsel submits that the petitioners have filed representation before the respondent number 4 as contained in annexure 8 series, but no decision as such has been taken, and therefore the present writ petition has been filed. The learned counsel for the respondents has submitted that though no counter affidavit has been filed in the present case, but the grievance of the petitioner can be looked into by respondent number 4, and for this the petitioner may approach respondent number 4 for filing representation, and the respondent number 4 can consider the grievance of the petitioners in consultation with respondent number 5. बाकी rest is same. ये order. The state petition is accordingly disposed of.
Item 11 WPS 2580-2523.
In this statement by India's order dated 30th/1/2024, the record of the I have mentioned in para 2 that one WPS 1296 by 2012 was disposed of by order dated 12/9/2012. It was not found on the website, but the record is before your lordship.
Where is that?
The record has been directed to be placed along with this.
There is no such direction.
Yes, by order dated 30th January 2012.
Okay, where is this?
Record is there.
Record दिखाइए
I have seen
1296.
that order.
Why was this was directed to me, please?
Because the Honorable Court wanted to know about the previous order.
Okay.
I have mentioned in para 2 that previously the petitioner approached this Honorable Court. The Lordship has just seen the order dated 12/9/2012 by Honorable Mr. Justice Alok Singh. I appeared on behalf of the petitioner. The claim of the petitioner was settled by Annexure 4 to the present date petition and in the earlier revision, and then below the direction was that 9,26,811 was found to be due payable to the petitioner, out of which not 4,25,000 something has been paid. Therefore, not the due is 4,98,686.
That's right.
Therefore, Lord, the petitioner was asked to approach the authority,
That's right.
and they were directed to pass a region order and to pay the amount within 90 days. That was the direction. Now, thereafter, when I made a representation, you will kindly come to Annexure 5, page 29.
Yes, I'm there.
Okay, Annexure 5, page on 16.
The amount has been quantified.
Yes, quantified. That has been. And then we will ask the principal to report as to whether the balance amount has been paid or not.
The total
Total
quantified amount is
9,26,811.
926,811.
There is no
Okay.
dispute.
You have been paid
Paid rupees 4,98,686.
98,686
So
paid.
due is not 4,28,125.
428,125.
25. Number of the registrar, to whom
For
I
certain
made
verification. It was
verification so by 16/11/21 after 9 years.
Hmm.
Then the principal, without consulting the record and without any record, says that you will just see page 30. That is the reason I approached this court. भुगतान फाइल आया जिसमें पहले का बकाया भुगतान हो चुका है और वर्तमान में जो दावा करते हैं उससे संबंधित कार्यालय में कोई रिकॉर्ड नहीं है, इसलिए बकाया से संबंधित आप स्वयं विचार कर इनके यहाँ पे
After 2012, what did you do?
That is the only 2021 letter.
So when did you approach them?
I approached not that is not the विषय में ही लिखा हुआ है.
No, when did you approach? What is the date of your representation? After that case was disposed of
in 2012.
in 2012.
Yes.
Then you slept over the matter.
But because I was in service, I retired only on 31st August 2020.
So
and
you see on 12/9/2021.
But admitted dues, that is
What
not in
admitted?
dispute.
How do you say admitted?
Because they have calculated this amount earlier to it also. The Rosi may kindly see that was in the previous writ petition. The amount payable was rupees 9 lakhs. That is the recorded in the previous order 9,26,811. And they have paid rupees 4,98,000 and that has been recorded in the earlier order also. The due was there.
The college was issued notice, no?
No, the notice has to.
No, even in the previous time, the college was never issued notice.
Because the university represented the previous writ petition. Mr. Mehta appearing on behalf of the university.
The amount as given by the petitioner is his assessment. It is not that the university or the college has
Yes,
quantified
that is
amount.
the chart, Annexure 3. It is not my assessment.
No, kindly see page number 29, Annexure 5. उपयुक्त संबंध में सूचित करना है कि श्री मुदल मुंशी उरांव शिक्षक केसीबी कॉलेज बेड़ो ने माननीय उच्च न्यायालय में निम्न बकाया के संबंध में केस दायर किया है. So it is not the fact that the university admits this amount.
आगे विदित हो अकाउंट नंबर सचनसा स्वास्थ्य संख्या सचनसा स्वास्थ्य संख्या सचनसा 3 लेटर आपके यहाँ से रिमाइंडर गया. इसका सूचना मांगी गई जो अप्राप्त है. बकाया का विवरण निम्नवत है.
You just tell us out of this entire amount, how and under what circumstances 498,686 was paid? That must have been paid after verification only.
Yes, that is what Annexure 6 the principle says that the amount has already been paid.
This amount cannot be verified, Mr.
Why
Why did you not approach them at appropriate
I
time?
have approached that
No,
is
you
the
are
reason.
not.
The
You are not.
reminders were sent by the university not on different dates.
Or you just see the dates.
Yes,
After
dates.
2012, what did you do?
2018.
Now
is
they
the
are not
reminder.
in a. You see, the question of payment will come only when the records are verified. The
Yes,
records are not available.
Your Lordship may kindly see the after verification of records Annexure 3. Your Lordship just see for a moment. The pursuant to order dated 5/12/2018.
Yes.
That is Annexure 2 to the writ petition.
Hmm.
Your Lordship just see the order was passed on 5/12/2008.
Annexure 3 is what?
Annexure 3 is the chart, not the
Who has prepared this chart?
the principal. Your Lordship just see principal of the college. Details have been given, how this amount has been arrived at.
193,653. This 193 figures in the total
Yes,
chart also.
this is only one account. This, your lordship, just see, it is date of joining, date of substantive appointment, and this is
in case, so you are claiming as per this chart?
No, claim for difference of amount as per UGC with 5th pay revision. Thereafter it has come to 6th pay revision, and they have decided, my lord, the claim, lordship, just see the previous order also, it discloses, my lord, that annexure 6, out of, they have assessed 9,26,811. The petitioner has received 4,98,686. Rest of the amount is not being released by the respondent number 2 for the reasons best known to them, such and such. Now, the university, my lord, respondent 2 and 3 are sleeping over the matter. The respondent number 1, 2, 3 submit
This is as per 6th pay revision.
Yes,
This
as per
calculation, annexure 3 is as per 6th pay
as per
revision.
6th.
You want payment as per?
That is as per, my lord, 5th pay revision on the top, page 23. Claim for difference of amount as
Now
per,
you want as per 6th pay revision.
now 6th pay revision. Now, my
For
lord,
the
my lord,
period?
Lord,
Period.
period, my lord, after that, my lord, that is period.
Which
my lord,
date?
Period from, my lord,
5th pay revision has come into effect from which date?
2006 onwards. 2006 onwards. Then
This
seven-
calculation is only with till 2000.
That is 5th pay revision.
That is
Up
only
to
till
2006.
No,
And
this is
thereafter-
only till 2000. This
2000,
calculation
yes.
is only till
That is
2000.
1996 to 2006. my lord.
No, it is only till 2000.
Since 1996.
Since 1996,
Yes,
it is
ma'am, that
only
is
till
my lord 5th
2000.
pay revision.
Yes.
96 to 10 साल के लिए होता है 96 to 2006 मिनट
No,
6
this calculation is only
Calculation
till
is
2000. Why
only-
don't you page number 27?
yes this is
It is January 2K. 2K is 2000.
2000 yes therefore it was on the basis of 5th pay revision
That's right.
and thereafter 6th pay revision comes into play in 2006 so I was in service in 2000 till 2020 so I am entitled to the difference of 6th pay revision and then my lord I approached this on court in 2008 the 2008 the first writ petition was disposed of that is annexure 1 page 6 page 18 Hiroshima Kainisi.
You just tell us what kind of confirmation do you want from the college?
We need
What
to-
records do you want from the college?
The college needs to certify
What?
that the amount is due and he has not been paid. Because the university does not have any records relating to the service of the petitioner at that particular
No,
time.
but you must have disbursed the amount. Then only it could have been paid to the petitioner.
No, the college will make a requisition.
No,
to
just
us.
a moment.
Yes.
Your records will suggest as to what requisition had come from the college and how much amount have you disbursed,
Yes.
right?
Yes, sir.
So there is no further requisition from the college.
The petitioner says an amount of rupees 5 lakhs and odd has been paid.
4,98,000.
Okay. So that would be the requisition the college might have sent to the university and we have disbursed the amount.
There is no further requisition from the college.
This is the letter of the principal.
No, requisition is another thing. You say that you are asking them to verify the records.
Yes.
You are not asking them to send the requisition for payment.
At least the principal will have to say that this amount is payable to him and it has still not been paid to him.
You see, the question of payment of this amount will arise only if you would have disbursed this amount. Is it your case that you ever disburse the entire amount?
No.
It is not your case.
No.
So you check your records that whether this amount, whatever amount, his simple case is that he wants as per 6th pay revision.
No. The dues are under different heads. Kindly see the annexure 5. The argument is something else.
That is mentioned in the paragraph 1 पंचम पुनरीक्षित वेतनमान में 1
Sir,
लाख
please
30,000.
साथ नहीं बोलते. When you
Sorry.
disturb them, it means that you are, yes, you just.
Sorry.
नंबर 1 1/96 से 31/3/2000 यूजीसी पंचम वेतनमान में 193,653.
That's
This
right.
was the amount of annexure 3.
That's right.
Exact amount.
Yes.
अप्रैल 2000 से अक्टूबर 2009 तक की अंतर राशि. This is like 5,92,000, nothing to do with 6th revision. July 98.
अंतर की राशि is what?
2000 से अक्टूबर 2009 तक की अंतर राशि under which head is given 5.
What is this differential amount of 5 lakhs? Mr. Sani?
Yes, ma'am, that is the pay revision, ma'am. This is the difference amount which I have been paid and which I am entitled to.
Which
That
pay
is
revision?
The sixth pay revision, because after 2006, sixth pay revision came into play, ma'am. So this is the
Sixth pay revision has come with from which date?
1/1/2006.
You are claiming from April 2000.
That is not the due.
No,
Difference
how
amount.
does it become due?
Because in your lordship,
Therefore, serial number 2 is not entirely
yes,
related to
yes,
sixth pay
just
revision.
appreciate. 1/1/96 to 31st March 2000. This
Counsel
is
for the
first.
parties are present. It appears from the records of this case that records of this case as well as the records of WPS number 1296 of 2012 that the petitioner had repeatedly approached this court. Earlier, the petitioner had filed writ petition WPS number 2849 of 2007. Thereafter, he filed writ petition being WPS number 1296 of 2012. But still, the grievance of the petitioner has not been redressed. From the perusal of order dated 12/9/2012, it is apparent that the petitioner had claimed an amount of rupees 926,811 and he had received rupees 498,686, and consequently it is submitted by the petitioner that an amount of rupees 428,125 is still due and payable to the petitioner. The learned counsel for the respondents has submitted that the claim of the petitioner has its breakup in letter dated 16/11/2021. It is not clear as to under which head an amount of rupees 592,701 has been claimed by the petitioner, mentioned at serial number 2, the period from April 2000 to October 2009. The learned counsel has also submitted that the university had acted pursuant to the order passed by this court, and pursuant to the order passed by this court on in WPS number 1296 of 2012 dated 12/9/2012, and has sent the matter to the concerned college for verification, and the concerned college has stated that whatever was admissible to the petitioner has been paid and there is no further record to support the claim of the petitioner. Counsel for the petitioner is directed to file a supplementary affidavit giving the head under which the differential amount for the period April 2000 to October 2009 has been demanded. A file kariye. What is it all about? The supplementary affidavit be filed by next week. The supplementary affidavit be filed by 28th of February. Post under the same heading post under the heading for admission on 6th of March. आप notice भी कर दीजिए. In the meantime, let notice be issued to the college, private respondent.
Yes, respondent 4.
Under speed post as well as under speed post, thusly in addition. Learned counsel for the respondents is also directed to seek instructions and file a contract.
Respondent 4.
Respondent number 4 को notice होगा.
एक पास हुआ है. Passover case from supplementary list item 6 WPS 6272/2023.
इसको 215 में बोले थे. इसको 215 में बोले.
Item 12 WPS 3743 of 2023.
This is case of compassionate abandonment. Earlier, the petitioner has approved this honorable court. She is married daughter of the deceased wife. It was disposed of the direction to approve the department for her consideration. Now they have again rejected my representation, saying that she was married in the year 2017 and the deceased, her father died in 2018. Before that, she was married. This point was earlier also raised and was considered by this honorable court.
Why have you rejected?
As per law, Your Lordship may come to page number 22 of the counter affidavit.
20?
22, Your Lordship, of the counter affidavit.
Yes, I'm at the same page.
Your Lordship. Your Lordship, there,
Clause number 4.
Your Lordship, for the dependents, Your Lordship, that is written here.
Yes.
So, in this, Your Lordship, Vivahit Putri is not.
It is there. परित्यक्त पुत्री एवं विवाहित पुत्री जो सरकारी सेवक की मृत्यु के समय उस पर पूर्णतः आश्रित रही.
हाँ, उनकी मृत्यु के समय.
हाँ.
उनकी मृत्यु.
Merely because a lady is married, does it mean that she is not dependent on her parents?
No, Your Lordship. That, for that, Your Lordship, परित्यक्तता जो word लिखा है, Your Lordship. For that, that is for those lady whose husband.
Abandoned.
Your Lordship.
Right.
Your Lordship, whose husband has left.
Left, right. And there is another term, Vivahit Putri.
Your Lordship, the full sentence में है जो सरकारी सेवक की मृत्यु के समय उस पर पूरे.
Why these two terms have been used? This Pariyat Putri and Vivahit Putri.
It was later modified in 2018. They have quoted old notification. And in this notification, Kalyani case has already been considered, which has been upheld by the Honorable Supreme Court, कि विवाहित पुत्री को जो है compassionate appointment पे consider करना.
It has been clarified here.
Yes.
Once.
That has been quoted.
Where is that Kalyani judgment?
It may fix as 215.
What is this?
Only those rules will apply which at the time of death of.
No,
the.
this is just clarificatory. This particular circular dated 9/7/18 is just clarificatory. It is just clarifying what is the meaning of Vivahit Putri dependent on her father. And it is not in dispute. You have not disputed. In the affidavit also she says that she is dependent on her father. That is not in dispute.
Lordship.
Get that judgment. 215 का बोर्ड खराब कर देते हैं ना आप लोग ऐसे ही. Absolutely unprepared. How can you be so irresponsible? You take the name of a judgment and you don't bring it. Your all arguments are online. Your client must be watching that how unprepared an advocate is in the court.
It has been considered.
I do not know the judgment. You can just give the name of a judgment, but I can't write it without reading it.
Your Lordship, this clause, Your Lordship, I'm explaining, Your Lordship. Vivahit Putri means the daughter who is married right now, but at the time of the death, she was a dependent, which means that she was not married.
Your interpretation, I am not satisfied.
Well, Your Lordship, you have stated it in the.
Your statement is not sufficient, right? I am not satisfied with your submission.
So, Your Lordship, the petitioner may prove his point, Your Lordship.
Sorry?
The petitioner may prove his point.
He has proved it already. I am asking you.
Your Lordship.
Married daughter dependent on her father is entitled for compassionate appointment even as per this circular. There is no confusion in my mind. Your authorities might be confused.
Your Lordship, the term is was dependent at that time.
Yes, a married daughter can certainly remain dependent on at the time of death merely by virtue of marriage.
Your Lordship.
Does the daughter ceases to be dependent on her father?
No, Your Worship, as per this rules I am speaking about.
No, even as per rule.
Your Worship.
On
Dependent, the
the
same
time.
this ashrit meaning, the dependence meaning, the same rule will follow, Your Worship.
We will reject your submissions. Then you challenge it. I'm not convinced with your submission at all. But he's saying that there is a judgment also to that effect. You just bring it. This is just clarificatory. Give him a copy of this circular.
Your Worship,
You have a copy? We'll take it up in that. We are not going to
I
adjourn
need
it.
to give him a copy, Your Worship.
You
so that-
take a copy and you get that judgment.
After 2 case or second?
Kalyani judgment, I do not know. पता है आपको? You just don't know about it. Come at 2:15 only.
ये वाला दे दीजिए।
अब दे दीजिए।
Next, call back.
Item 13, WPS 375 for of 2023.
Yes.
I am praying for adjournment because I am not properly ready today. This for regularization, some judgment.
What judgment?
75
You are not covered by the circular. As simple as that.
नहीं 75 तो रेट पिटीशन डिस्पोजल हुआ है 24 तारीख को 15 जनवरी को उसको खाली देख रहे हैं देखिए
Which court has disposed of the writ petition?
कोऑर्डिनेट बेंच
You just tell us. Which court? Coordinate bench means which court? Court number?
कोर्ट 7 मैडम
Honorable Justice S. Patil. The order has been uploaded?
yes
Okay, give me the judgment.
but
Dikhai.
I may be allowed to
We will allow you. You don't read the judgments of the court. Where is that judgment?
tell the
Give me the case number.
केस नंबर है 1021 2020
1021 of
2020
2020. इसका ना कॉज टाइटल मत निकालिएगा. खाली जो फाइंडिंग्स है वो निकाल के दीजिए. First page and the rest of the. It has been allowed.
तो उसमें बोला गया है कि कंसर्न सेक्रेटरी के यहाँ प्रेजेंट करके हाई लेवल कमिटी बनेगा एंड हाई लेवल कमिटी विल डिसाइड द इशू.
So therefore, if your case is to be considered, that will also be considered. It is a case of सफाई कर्मचारी.
मेरा सफाई कर्मचारी
And it is in that case also it is a case of सफाई
75
कर्मचारी.
writ petition 75 writ petition has been disposed with his comment.
You just see in your case there was a clear direction that your case will be considered in terms of the circular of 2015.
Yes,
Right?
That was
As per the circular, you are not entitled. Right?
लेकिन हम दो
Just a moment.
हम
As per the circular, you are not entitled. And so far as the subsequent judgment is concerned, if your case is to be otherwise considered, that can always be considered. But you see, the question of framing any high-level committee has cropped up because as per 2015 circular, many people may not be under zone of consideration, right? But so far as 2015 circular is concerned, you are not entitled.
इसीलिए बोल रहे थे कि
इसीलिए बोल रहे हैं.
नहीं, हाँ,
Therefore, even if we hold that you are not entitled as per 2015 circular,
but
we can always say that if you are entitled for any benefit out of whatever committee is being constituted, this order will not be an impediment in passing an order by the authority. Simple.
but हम 20 साल more than 20 years these persons are coming.
We are not bothered about
But
it.
therefore only
They-
one.
you
कल
see,
रख दीजिए
we-
जो कल रख दीजिए हम आई नॉट हम कल के लिए हम तैयार हो जाएंगे. ये खाली दो एक ऑल ऑफ ए सडन आया इसीलिए हम तैयार नहीं हो पाए. एक खाली एक एडजॉर्नमेंट चाहिए. आई नो
Just a moment. कल भी तो आप जजमेंट नहीं लेके आएंगे ना, तो हम तो पढ़ लें
नहीं
जजमेंट.
हम जजमेंट लेके आएंगे तो
आपकी
हम
आदत
note-
है, आप जजमेंट कभी लेके नहीं आते.
अभी खोजे हैं अभी तुरंत मिला है इसीलिए हम नहीं दे पाए.
Litigants may be different, but counsels are the same, always.
Findings.
the matter is regarding pay anomaly. और उसके बाद?
Regularization का है. It is also quoted last page में kindly be seen. नरेंद्र नाथ तिवारी का जजमेंट भी कोट हुआ है. हम थोड़ा सा पढ़े हैं लास्ट.
ये पूरा फाइंडिंग से पेज 54 दिया आपको. क्या बोले थे? कॉस्ट टाइटल नहीं देने, बाकी सब देने के लिए.
लास्ट पेज.
सो कंप्लीट करिए.
60 पेज.
The learned counsel for the parties are present. The matter relates to regularization. A direction was issued by this court earlier. You were the writ petitioner?
No.
By this court earlier in WPS number 462 of 2015.
Yes.
Is that correct? In WPS number 462 of 2015, to consider the case of the petitioners in terms of 2015 rules for regularization issued by the Department of Personal Administrative Reforms and Bhasha by notification dated 13/2/2015. The learned counsel submits that a coordinate bench of this court has passed certain directions in connection with regularization in WPS number 1021 of 2020. He submits that the matter be placed tomorrow, post tomorrow. कल adjournment मत मांगिएगा और 10:30 बजे आ जाइएगा. Tomorrow is a revision bench, but I am posting this case tomorrow. Tomorrow is criminal revision before this court. But as a special case, I am posting it tomorrow. So both of you should be present. Till the next time.
Item 14 WPS 3761 of 2023.
In this case, the petitioner is challenging the selection of respondent number 6 on the post of Anganwadi Sevika and further seeking.
Counter file, did you want to file any rejoinder?
I have a very small case, Lord, that I am challenging the appointment of the respondent number 6 on 2 grounds. The first ground is that
Notice has been issued?
No, Your Worship. The first ground which it is coming for the first time. The first ground upon which I am challenging her appointment is that I am possessing a higher qualification or lesser.
Did you participate in the process?
Yes, only we two participated in the leadership.
You have a higher qualification. What
My
is?
case is that I have a higher qualification. I am also a BA. The respondent number 6 also is a BA. However, I am BA first class for leadership, whereas the respondent number 6 is BA second class. Since there was a similar qualification, an Amsabha was conducted in which the respondent number 6 got selected. However, regarding the Amsabha, I am also challenging the manner in which Amsabha was conducted, because in that the people who participated there were many minors as well as the people from other villages also participated and had signed.
From where is it?
Lord, it is my
where is it mentioned in your petition?
Paragraph 20 onwards, if I may.
Read it, please.
That it is humbly stated and submitted that it is even evident from proceedings of Amsabha dated 13/2022 that the decision was taken on the basis of majority voting only because both the candidates had identical qualification. In fact, there were certain discrepancies in the voting also, as the proceedings of the Amsabha contained signatures of many members, including minors, who are not members of particular area and hence not eligible.
Absolutely vague.
And subsequent.
This is absolutely vague. Tell us who were the minors. You have not stated.
Yes, sir.
Then?
However, my primary bone of contention or leadership is that, and since I have also annexed the educational certificate of the respondent number 6, which I had obtained through RTI, your leadership. In that, it is apparent that the respondent number 6 was BA second class.
How does that make a difference? Does it make you higher qualification merely because she was second class?
Yes, Your Lordship, and I.
Under what circular? That is just a qualifying competing claim. Does it say that a person who has better marks will be treated as higher qualified?
Lord, if two similarly situated persons are applying for a Lord,
If you have some rule, you tell us. Otherwise, I do not agree
and
with your
apart from
suggestions.
that, Your Ladyship, so, raising these grievances, because since there is a factual grievance which I am raising, Your Ladyship, I preferred a representation before the Deputy Commissioner, Your Ladyship, which is at annexure number 12. That representation has not been decided. The counter affidavit has been filed by the state, Your Ladyship. In that particular counter affidavit also, my lord, regarding my representation, my lord, the counter affidavit is silent, Your Ladyship. Moreover, Your Ladyship, in a similar matter in which there was a dispute regarding, my lord, the parity of regarding who is higher qualified or who is lesser qualified. A writ petition was preferred, and in that case, Your Ladyship, the coordinate bench was pleased to remand the matter up to the Deputy Commissioner, Your Ladyship.
No, we will decide the issue. We will not
And
remand.
so my case is that
This is the respondent number 8 had MA Sociology, right?
Yes.
And the petitioner had what qualification? दोनों चला गया, लीजिए उनको वापस करिए 4021. What is this?
So my
No, you have placed this judgment, you place it.
Yes, Your Ladyship.
You say that there was a remand on the point as to whether
Yes, Your
same qualification will be.
No, mine was that since there is, I am claiming, Your Ladyship, that I have a higher qualification by virtue of being possessing higher marks, Your
That's
Ladyship.
do you have any circular to that effect? That's it. Tell me. If you heard the learned counsel for the parties, this petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the main grievance of the petitioner are twofolds. A, the petitioner as well as the private respondent, though having BA degree, but the petitioner had first class marks.
Yes,
And the private respondent had second class marks.
Yes.
And therefore the educational qualification of the petitioner should be treated as higher qualification. The second point is that he has specifically stated in paragraph number 20 of the petition that in the Aam Sabha, certain minors had also participated, and therefore the entire proceeding of the Aam Sabha is vitiated. The learned counsel for the respondent state has filed a counter affidavit and has opposed the prayer, and has submitted that both the
Candidates.
Both the candidates were having a qualification of graduation, and merely because the petitioner had higher marks in graduation, that does not make the petitioner having higher qualification. She also submits that the allegations made in paragraph 20 of the petition are vague, and the allegation has been denied in the counter affidavit in paragraph number 21, and no rejoinder to the counter affidavit has been filed. After hearing the learned counsel for the parties and considering the grievance of the petitioner, this court is of the considered view that merely because the petitioner was having first class marks in BA and the private respondent was having second class marks in BA, the same as argued by the petitioner, the same does not make the petitioner having higher qualification. The petitioner has not placed on record any circular or provision, any circular or guideline by the state which makes the petitioner higher qualified merely by virtue of having more marks than the private respondent. So far as the second grievance of the petitioner, as stated in paragraph 20 of the petition is concerned, absolutely vague statement has been made by the petitioner. No particulars of the minors who had participated in the Aam Sabha has been mentioned in paragraph 20. The allegation made in paragraph 20 has been denied by the respondents in the counter affidavit. In paragraph number 22, no rejoinder has been filed to the counter affidavit. considering the fact that the statement page in paragraph 20 is absolutely vague, no, this court is not inclined to take into consideration such vague allegation made in paragraph 20, which has been denied by the counsel for the state in the counter affidavit. Accordingly, there is no merit in this writ petition, which is hereby dismissed.
Right.
Item 15, WPS 3890 of 2023.
So in this case, the mother of the conducting advocate has died.
This case may be listed along with other cases.
What is the matter about?
For appointment of the post of trained graduate teacher.
Trained?
Trained graduate teacher, and locus cases are in hearing,
No, what kind of, any advertisement has been issued?
Madam,
Yes,
advertisement was issued, Your Lordship, in 2016, Your Lordship. Result was, Madam, that is Soni Kumari case, Your Lordship.
Soni Kumari.
Scheduled district, non-scheduled.
Yes.
In terms of the order passed by the Honorable Supreme Court, we are preparing the state-wise merit list.
That's right.
Now they are saying that our cases should be considered.
Whose case?
They are saying.
So everybody's case will be
everybody's
considered.
Case is being
Is under
considered.
consideration.
Similar
What is
cases
your
are
advice?
pending for adjudication
Sorry?
before this honorable court.
How many cases?
Similar cases.
Case number?
WPS 582 of 2023, WPS 6775 of 2018, WPS.
So, we will decide this case.
This
Madam,
case
in that
may be-
case, Your Lordship, the
there is no counter affidavit in this case, ma'am.
Without
This case
counter
may be-
case cannot be decided.
No, madam.
Just tell us.
Madam, basic foundation of filing the writ application is missing, Your Lordship. He is praying for the writ of mandamus. No representation, no details about the petitioners, Your Lordship, in the writ application. They have only annexed the admit cards of the petitioners, Your Lordship. How we will ascertain? Basic foundation is missing. Kindly have a look to the pleadings made in the writ application. In the entire, altogether, Your Lordship, there are 21 petitioners, 22 petitioners. But here, they have not made any statement in the pleadings, Your Lordship, what is their roll number, what was their position, what was their subject, when the advertisement was floated, for which district they have submitted their application form. There is nothing. Basic thing is missing, Your Lordship. Only they have quoted the orders.
Para number 22, you see para number 22. Page number 30. The order dated 2/12/2022 mandates that there is no bar as to the present petitioners being part of the revised merit list. Revised merit list is under preparation.
That
That has been prepared or it is?
My lord, we have already published, Your Lordship, result of the several subject, and several for selection process has already been completed for several subject. But in the writ application, Your Lordship, they have not mentioned any subject. What is their roll number? What is their subject? Can you see?
My lord, we have annexed the admit cards, my lord.
Merely because then I will have to find out
I will
about
file the supplementary affidavit, my lord.
basic facts is missing. How it is maintainable?
All the petitioners herein secured more marks than the cutoff marks as published by the respondents.
बस वही वो statement हो गया.
My lord,
No
I will
details.
file supplementary affidavit annexing the all
You see this particular writ petition in the manner it has been filed cannot be adjudicated.
My lord, actually this case has been filed by an advocate of Patna High Court, my lord, and similar case is analogous to WPS 111 of the
So, incompetence of yours has gone to Patna also.
My lord, then
You don't give
time may
foundational
be
facts
given
of the
to
petition.
time may be given so that he may come and argue in this case.
What is the status of this case? WPS number?
It is pending and
19/12/23.
it is to be proposed to be listed on 11/3.
Fixed है. Date से fixed है.
Yes.
Judicial office है.
Judicial order में इसमें date उसमें
11/3/24
not taken होता उसके बाद
देखिए कौन सा दिया है.
11.3.
24.
Would you like to file a counter?
What difficulty is this, Your Lordship, without details of the petitioner, Your Lordship?
You just need to put on record that the order of the Honorable Supreme Court has been already complied. Once it is complied, the recruitment process is over. Matter ends.
My Lord, only difficulty is, Your Lordship, subject, Your Lordship, pleasure. Altogether 26 subjects are there. My Lord, several subjects we have completed, Your Lord, history, civics, chemistry, biology, etc., Your Lordship. Unless and until, Your Lordship, he will not give details that for which subject they are applied, how we can, my Lord, this is the difficulty which is being faced by us, Your Lordship.
Okay. The learned counsel for the parties are present. The learned counsel for the petitioner submits that the present case is an offshoot of the case decided by the Honorable Supreme Court in Civil Appeal number 4044 of 2022 and connected petitions within bracket Soni Kumari versus
Soni Kumari versus State of Jharkhand.
State of Jharkhand. यही नंबर है ना?
नहीं, वो दूसरा है. That is Your Lordship contempt.
नहीं, सिविल अपील नंबर 4044.
सिविल अपील नंबर तो ठीक है. उसके बाद देर आफ्टर द contempt application was also filed. My Lord, if Your Lordship can go to page number 348.
My
Lord, some guidelines have been issued by the Honorable Supreme Court.
अच्छा ऐसे लिखिए offshoot of various judgments and orders passed by the Honorable Supreme Court, whereby the respondents were directed to prepare fresh merit list for the purposes of filling up the vacancies. The learned counsel for the respondent JPSC Staff Selection Commission has submitted that the foundational fact with regard to the petitioners are missing in the writ petition. He has submitted that with respect, as per his instructions, with respect to some of the subjects, the list has already been finalized and the appointment have already and the recommendations have already been made. But in absence of basic foundational facts with regard to the petitioner, no counter affidavit can be filed in the present case. The learned counsel for the petitioner submits that he shall file a supplementary affidavit in the present case giving the details with regard to each and every petitioner in the present case. He has also submitted that similar issue is pending before this court in a batch of writ petitions being WPS number 582 of 2023 and analogous cases, and the next date in those cases is 11/3/2024. He has also submitted that in the batch one writ petition being WPS number 677, one case is of the year 2018, that is WPS number 6775 of 2018, which is not in the roster of this bench. He has submitted that this case may be tagged along with the batch matters so that the case be heard on 11/3/2024 itself. And in the meantime, he shall file the supplementary affidavit. Considering the submissions made, let the supplementary affidavit in the present case be filed by the petitioner within a period of 1 week from today. The office is directed to place this case before the Honorable Chief Justice.
1 week for which time?
आप लोग बीच में क्यों इंटरप्ट करते हैं? Let the matter be placed before the Honorable Chief Justice so that this matter be tagged along with so that this matter can be heard along with the batch of writ petitions. In view of the fact that one of the writ petitions being WPS number 6775 of 2018 it does not fall in the roster of this bench. Right? Chalo.
Item 16, WPS 4920 of 2023.
In this case, on 12th of December, you must present this to direct respondent to file counter affidavits.
You have filed counter? Yes?
Well, for state we filed the counter affidavit. University has not filed now.
Who is? State has filed?
University is the contesting party lawsuit because this is the matter related.
Who is for the university? Do you want to file a rejoinder to the state's counter?
Yes, I will file, but counter of university will be necessary.
Who is for respond number 5?
This is respondent.
The college. Has it been served?
Notice has been served. Notice Ranchi University will file.
WPS number 4920 of 2023. Counsel for the petitioner and the state is present. From the office note, considering the office note, let fresh notice be issued to respondent number 5 through speed post, thusly in addition. In spite of order dated 5/12/2023, a counter affidavit has not been filed by the university. Neither counter affidavit has been filed by the university nor the counsel for the university is present before this court. However, in order to give one more chance, let the counter affidavit be filed by the university by 28th of February 2023. Post this case on 11th of March 2023. The supplementary affidavit in connection with service of notice be filed before this court by 29th of February.
Admission.
Under the heading for admission.
Item 17, WPS 5545 of 2023.
Ms. Petitioner.
Pursuant to the order passed by the coordinator, I had this supplementary affidavit bringing on record the notification.
That is not there on record. देखिए supplementary affidavit file किया क्या इसमें?
Yeah.
We'll find it out. Notice were issued to private respondent.
Not issued, not required to be issued.
What is the ground?
The ground that the petitioner was earlier selected and provisionally selected on the post of Sahika, and without cancelling her candidature, a fresh samsa has been held.
क्यों नहीं है 5 तारीख को फाइल हुआ?
Fresh samsa has been held.
अपडेट नहीं करते हैं. Fresh samsa was held.
And on that
your
basis,
services were not confirmed.
Not
all
confirmed.
the selections are subject to confirmation.
Subject to confirmation.
So it was not confirmed.
No, it was not confirmed, and the petitioner has made application before the DDC, who is the competent authority for recommendation, and he has given direction that why second Amsabha is going to be held.
Where is the direction?
That is that I have annexed in page 39, annexure 6.
This is 20. 2021.
Yes. And I have been selected by annexure 1, that is page 31.
Where do you see? You see,
Yes.
नियुक्त दिनांक 10/12/2020 को उनका चयन होने के बावजूद
पुनः नियुक्ति हेतु आम सभा का आयोजन करने संबंधी अभ्यावेदन पत्र कार्यालय को प्राप्त हुआ।
आगे बढ़िए।
उसके प्राप्त अभ्यावेदन की छाया इस पत्र के साथ संगमन करते हुए आदेशित किया जाता है कि पत्र में अंकित तथ्यों के आलोक में नियमानुसार कार्रवाई करते हुए कृत कार्रवाई से 24 घंटे के अंदर अध्यक्ष को अवगत करना सुनिश्चित करें। But they appointed respondent number 4 on the basis of compassionate appointment, and that compassionate appointment circular I have brought in record. Her mother died in 25/3/2020, and the circular which is relied by the respondent, that is circular dated dated 30/9/2022, and in this circular it is also mentioned that यह नियमावली अधिसूचना निर्गत होने की तिथि से प्रवृत्ति हो। So this circular will not be applicable for compassionate appointment as per number 7. That is my question.
Learned counsel for the parties are present. You have annexed the circular?
Yes, madam, I have filed also, but
where is it?
उसके बाद वाला पेज में और सर्कुलर में भी बोल रहा है कि ये compassionate appointment में किया जा सकता है, but other eligibility criteria has to be seen. That I already marked.
Is there any time period for filing an application?
For compassionate appointment?
Yes.
But here the circular came in the year of 2022, and there is no such. But Am Sabha is required to be held, and point number 6 is mentioned here with regard to the compassion.
I have seen point number 6. I want to know, is there any time frame for?
No, not such time frame is mentioned there. Only it is mentioned that any.
When were you recruited?
Hello?
When were you actually given the appointment?
That is annexure 1.
When date?
Date, madam. And 10/12/2020. Without cancelling my candidature, without
The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the petitioner was selected as
Anganwadi
Sahayika by provisional appointment, for which provisional appointment letter was issued on 10/12/2020. He submits that while the candidature of the petitioner was still surviving, the private respondent number 7 has been appointed on compassionate ground. He submits that the circular making provision for compassionate appointment has been issued by the state government only on 30/9/2022, and therefore the compassionate appointment of the private respondent cannot be sustained as the petitioner was already selected prior to coming into force of the circular.
And her mother died on 25/3/2020.
He has also submitted that the mother of the private respondent had expired on 25/3/2022, which is prior to the circular issued for compassionate appointment. Issue notice to the respondent number 7 for which requisites under registered cover, under speed post as well as ordinary process, registered cover, speed post and ordinary process be filed by day after tomorrow. The office is directed to track the speed post delivery and prepare appropriate office note in connection with service of notice. Post this case on 13th of March, on 13th of March 2023, awaiting service report. 2024. Okay, next. Discuss supplementary affidavit खोज के लगा.
Yes, society. Item 18 WPS 6151 of 2023.
Lordship, I prefer short passover as my experience to solve it is on
What is the matter about?
Lordship, the matter is related to the fixation of pay scale in 5th, 6th and 7th division of pay scale and also for the payment of retired benefits.
What is the counter affidavit? What counter affidavit have you filed?
Yes, Your Worship. On behalf of university, I have filed, Your Worship.
Saying what?
Yes, Your Worship. In the council affidavit, you may kindly see the para 6, Your Worship. University has sent to the Higher Education Department, Your Worship. They are pending there, Your Worship.
You have sent in 2012
Yes, Your Worship.
and thereafter in
thereafter reminder I have
2024.
also given, Your Worship.
Who is the concerned authority who will take a call?
Higher Education Department, Your Worship. The respondent number.
To secretary. It has been
Yes.
sent to the secretary.
Yes, yes.
You are for the state.
Yes, yes.
To take a decision.
Yes.
The matter has been recommended to you
Yes.
for all the petitioners.
Yes, Your Worship.
This writ petition has been filed for the following relief. The learned counsel for the university submits that a counter affidavit has been filed in the present case stating that the only one petitioner, only one petitioner.
Here only one.
For all the petitioners we have sent it. For all the petitioners.
No, on one only. All the petitioners.
Okay. The learned counsel for the university has referred to paragraph 6 and 7 of the counter affidavit and submits that the matter is pending before the secretary higher before the respondent number 1.
Two.
Sorry, before the respondent number 2. As a required recommendation has already been sent by letter dated 16/2/2012 and thereafter a reminder
On the basis of the letter given by the Director Higher Education, it's also mentioned, Your Worship, 12/12/2008 issued by Director Higher Education. उसी पारा में है नीचे.
or that's it, it's okay.
Annexure
By
one
letter
and-
dated 6/2/2012 and subsequently by a reminder has been issued by letter dated 10/1/2024.
Yes.
But no decision has been taken and the matter is pending before the state authority. The learned counsel for the state has submitted that although no counter affidavit has been filed by the state, but if the matter is pending before the respondent number 2, the same will be decided and the writ petition may be disposed of. After hearing the learned counsel for the parties, you have forwarded only for 5th UGC pay scale, right? And they are claiming 6th and 7th.
First
Also.
fifth होगा, fifth में allow होगा, तभी 6, 7 तक. This is the Sanskrit University, Your Worship. This is the case of the Sanskrit University. As
first
said, the
fifth has
first
to-
fifth आएगा उसके बाद ही 6, 7 तक.
It is on State University. The learned counsel for the university has also submitted that, as per the counter affidavit, the matter regarding 5th pay scale of the petitioners is pending before the respondent number 2, once the UGC fifth pay scale is finalized in favor of the petitioner number 2, then only there is a question of consideration of 6th and 7th pay division. He submits that the decision is awaited and therefore further recommendation in connection with 6th and 7th pay division has not been sent. Hol sakta hai? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, and considering the nature of relief which has been sought for in the writ petition, it appears that the university has issued required letters to the respondent number
2.
Two.
2 is the, here is the secretary, but it is the director.
It has gone to the director.
Yes, Your
To the
No, really.
director is not a party.
Not a party.
Has
Secretary,
been-
only secretary made his part.
Has been sent to the director of higher education.
Yes. Proper respondent is director.
He is going to take the decision.
Yes, sir.
The director has
Director.
Manav Sansadhan Vikas Mantri is what? Vikas Vibhag?
Higher and
Human
technical
Resources
is-
Department. To the director within bracket higher education, Human Resources Department, State of Jharkhand. It further appears that till date no decision has been taken so far as the claim of UGC fifth pay scale is concerned. Accordingly, this writ petition is disposed of, enabling the petitioner to file a fresh representation before the aforesaid authority, namely the director within bracket higher education, along with a copy of the writ records, so that appropriate decision in connection with claim of the petitioner with regard to UGC fifth scale is taken. The needful be done by the said authority within a period of 2 months from the date of receipt of the representation. Once the decision is taken with regard to entitlement of UGC fifth pay scale, thereafter the petitioners may shall file their representation before the university, raising their claim in connection with 6th and 7th pay division. And the university shall also take appropriate steps in accordance with law, such that the grievance of the petitioner is ultimately redressed. If the petitioner is found entitled for any amount in connection with their grievances regarding fifth pay scale, the said authority shall, pursuant to the reasoned order to be passed by the said authority, appropriate steps be taken so that the monetary benefit out of the same is also remitted to the petitioners within a period of 3 months from the date of the reasoned order. A copy of the reasoned order be forwarded to the petitioners by the aforesaid authority. That should be sufficient.
Lordship, may I submit on it? The matter is not only 5th, 6th and 7th also.
They have recommended for 5th.
Only 5th.
Let them take the decision on 5th. 6th and 7th will
The
follow.
UGC regulation adopted by the university, that is 1988 UGC regulation, that is in respect to 5th. 2010 UGC regulation.
Please hold on, Mr. Sauravarun. Let them take a decision on 5th.
And the Lordship may indicate subsequently 6th and 7th.
You have come after the order has been dictated. Chaliye.
Under heading with orders with effect, item 1 WPS 1003 of 2023.
Time till 28th February is granted to the petitioner to remove the surviving defects preemptively. If the defects are removed, pose this case on 6th of March
Item 2
under the appropriate heading.
Item 2 WPS 1005. Item 3 1006 of 2023.
Same order.
Item 4 1033 of 2023.
Same order.
Item 5 WPS 1083 of 2023.
Same order.
Item 6 1085 of 2023.
Already said 3 weeks time.
28th will be almost 3 weeks. Same order.
Item 19 WPS 6173 of 2023.
This is for just a discharge reduction, but before that, I must point out that in para 24 there is a wrong statement has been. So I am permitted to delete that, or I may be permitted to file an application for deleting that application, because there is in para 24 we have stated that petitioner has been acquitted, but he has not been acquitted.
What is the status?
That is still pending. So criminal case is still pending.
You have been so this writ petition you can file this writ petition once depending on you cannot get the relief unless you are acquitted.
My case is your lordship. Petitioner was once dismissed, your lordship, by next 3. But by next 4 he was taken taken back in service, your lordship. Next 4 that is on record, your lordship. Thereafter again after 3-4 months the next.
After conviction you must have been dismissed.
Conviction no, is still pending, your lordship. There is no conviction till date.
There is no conviction till date. Criminal case is pending.
Yes, your lordship. I have stated that
you have been suspended.
Not suspended. When he was taken into custody, on that basis he was dismissed from service, discharged from service because he is contractual employee. Next 3 is that, your lordship. And when after getting bail, your lordship, he submitted his joining, that was accepted, and except for that is that his joining was accepted. Thereafter next 5 again they have said no, that is because your services wrongly has been.
Rightly so.
Okay. If lordship sees once they have taken your lordship decision, if your lordship sees the next 3, 4 and 5, your lordship.
What was the allegation against you?
That is prevention of corruption.
Then?
But that is still pending, your lordship.
What is still pending?
Your lordship, that case.
Merely because you are no.
I'm not saying that I'm in a statement, your lordship. Once they have taken a decision, your lordship, they have not issued any so cause.
Estoppel will apply.
No, your lordship, once they have taken any decision, and that has become finally.
Your contractual period is over?
Contractual is for since 2005 he is working continuously.
No, but there is no extension of your contractual work. Is there any extension order?
Since 2000, after
every year it is extended, isn't it?
2000 when he was reappointed, your lordship. Then that order was complied and he has submitted his joining.
I want to know, it is a contractual appointment. So contract period must have been over by now.
That way they all the time they are extending their lordship for every person.
For you it has been extended.
So that is, your lordship, that extension is there or not, because there is no specific extension in any of the cases, your lordship. In this case, your lordship.
Please don't tell us.
The order also says no that the mistake that has been committed has been rectified not by this order.
It's a mistake, absolutely.
Yes.
You are in accused in Prevention of Corruption Act, and then you have remained in custody for how many days?
That is not on record.
You don't have anything. You make an incorrect statement also.
No, I'm not saying that. I've stated at instance.
You were apprehended.
About 3 months he remained in custody.
Lordship, the first thing, your lordship, that even in contractual, the first order letter, your lordship, that said that he was discharged. That was also without any notice and anything, your lordship, only on the basis that he was taken into custody, therefore he was discharged. If your lordship sees an
is that not sufficient?
Even for the
is it for natural justice? You see, what is natural justice? What do you have to say? right?
After
But
he was
the fact that you were taken into custody in a trap case is not in dispute.
that is not in
So
thereafter, Your Lordship, he was taken back in service, Your Lordship. Thereafter,
no
Your Lordship,
estoppel.
no,
There
no
cannot be
step,
any
Your Lordship. If Your Lordship sees the Annexure 4 where he has been taken back in service, Your Lordship. Annexure 4, page 29. May I read, Your Lordship?
No, we can't give you any relief of that kind.
My simple queries, Your Lordship, that they have not given any. They have
No
not
show
followed
cause is
any.
required. That was wrongly issued by them. They have corrected their own mistake.
The first letter, Your Lordship, first letter even, Your Lordship, that order has also been issued without any show cause. Even the show
Need
cause.
not, no show cause is required because it is an undisputed fact that you were taken into custody in connection with your listen to the order. Listen to the order. WPS number 6173 of 2020. The learned counsel for the parties are present.
Your Lordship, there is one judgment, Your Lordship, that even if any order
In
is
contractual employment cases, if a person is taken into custody in a trap case, he has to continue.
No, I'm not saying that.
What judgment?
If they even contractual employment in termination order, if the punitive order there is, Your Lordship, the termination order, then they should follow the principle of natural justice. That
We will take care of your submissions. Don't worry about that. This writ petition heard the counsel for the parties. This writ petition has been filed for the following relief. At the outset, the learned counsel for the petitioner has submitted that due to inadvertence, an incorrect statement has been made in paragraph number
24
of the writ petition that the petitioner has been honorably acquitted in the criminal case and therefore the petitioner is entitled for reinstatement. The learned counsel submits that the criminal case against the petitioner, which was instituted in a trap case under Prevention of Corruption Act, is still pending and the petitioner continues to be on bail. The petitioner has submitted on the merits of the case. The petitioner has submitted that after the petitioner was arrested in the trap case on 26/8/2016, he was discharged from service on 30/8/2016 and thereafter upon grant of bail in BA number 8844 of 2016, he was taken back by the order dated 16/12/2016. The petitioner had remained in custody for a period of 3 months.
About 3 months.
About 3 months. He has also submitted that thereafter, by another order dated 13/12/2017, the petitioner has again been discharged by stating that the earlier order dated 16/12/2016 was wrongly passed. The learned counsel submits that no show cause was issued to the petitioner prior to issuance of the letter of discharge dated 30/8/2016, nor any such show cause was issued to the petitioner while discharging the petitioner by letter dated 13/12/2017. And therefore, the orders of discharge, be it 30/8/2016 or 13/12/2017, are fit to be set aside on account of violation of the principles of natural justice. The learned counsel for the respondents has submitted that even as per the petitioner, it is not in dispute that he was taken into custody in a trap case and has remained in custody for 3 months, and therefore the impugned order do not call for any interference. The learned counsel has submitted that the petitioner was caught red-handed in trap case in connection with the discharge of his official duties, and therefore the order of discharge do not call for any interference. He has also submitted that the petitioner was a contractual employee. Right? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is of the considered view that on account of the undisputed fact that the petitioner was a contractual employee and that he was arrested in a trap case on 26/8/2016 while taking bribe, and in connection with the said case he had remained in custody for 3 months. The order dated 30/8/2016, which is said to have been passed without giving any opportunity of hearing to the petitioner, cannot be said to be vitiated in law. This court finds that while order dated 16/12/2016, the petitioner was taken back in service on account of the fact that he was released on bail in BA number 8844 of 2016, and the said order has been rectified by the order dated 30/12/2017 by stating that the order dated 16/12/2016 has been wrongly passed. It cannot be disputed that in a case of Prevention of Corruption Act, where the petitioner was taken into custody and he had remained in custody for 3 months, there cannot be any occasion to take back the petitioner in service. The fact remains that the criminal case against the petitioner is still pending. In view of the aforesaid facts and circumstances, this court does not find any merit in this petition, which is hereby dismissed.
Only one correction. He says contractual. He says दैनिक पारिश्रमिक means daily wages.
Oh, उसमें लिख दीजिए. Moreover, the petitioner was on daily wages as per the writ petition, and therefore no case for interference in the impugned order is called for.
Item 20, WPS 6348 of 2023.
No liberty is there. That liberty is always there. Yes.
Madam, in this petitioner has prayed for a direction upon the respondent Jharkhand Staff Selection Commission to allow her to deposit the examination fees, which she could not deposit because of the error in the website of the Staff Selection Commission, madam. With regard to which, madam?
The error was only for you, or it was for many persons?
Madam.
How many petitioners are there?
Petitioner, the petitioner is sole petitioner. Madam,
What error? What technical error was there in the website? Show me the screenshot.
Madam, it is at Annexure 7, page 97. The last line, madam. Whenever the petitioner, after having obtained the registration number, went for deposit of the examination fees, it shows please verify the data entered and the last line, madam, after exclamation mark.
Data entered.
Madam.
You might not be giving your correct account
Madam,
number.
all data were correct, my lord. I even represented, sent an email to the staff selection committee.
Where is that?
My lord, Annexure 8. My name is so and so.
When did you represent?
On 31st of October 2023.
Was that the last date for submission of?
My lord, it was the last date, my lord.
31st was the last date?
My.
And you filed your representation on?
On the
31st
same
October.
day itself, 31st October itself.
It
was forwarded, my lord. But before that, it was sent on 257. I have pleaded in my writ petition.
Where do I get 257?
My lord. It was 757, my lord. Para 13, page 12.
7:57 at the night.
My lord.
So that time is over?
No, my lord. It was open till midnight. My lord, kindly see annexure, the schedule which was revised, which is at annexure 4, page 96.
When is the examination going to be?
No date of examination has yet been published, ma'am.
The counsel for the parties are present. You file your counter. Short counter, jaldi se. The learned counsel for the parties are present. Who has to file the counter?
Staff selection.
State is a formal party.
Ma'am.
it is submitted that the state of Jharkhand is a formal party and therefore no counter affidavit need be filed by the state of Jharkhand at this stage. Counsel for the respondent number 1, 2, 3.
1, 2, 3 is JSC, 4, 5, 6 state.
Okay, learned counsel for the respondent number 1 to 3 is directed to seek instructions and file a counter affidavit in the present case by 16th of February, post on 21st under the heading for admission. Next case. There must be many such cases. You have filed many?
They have contacted, but I am not filed.
They must have filed.
Item 21.
You find out,
WPS.
give me the list, right? All the cases you must be party. Yes.
Item 21, WPS 6382 of 2023.
Petitioner is a retired employee of CISF. He has been paid other retirement benefits, but medical allowance has not been given to him.
Where is your representation?
Representation in excess of 4.
My instruction, all the grievance has been fulfilled.
Including medical allowances? If not, you consider. If it has been paid, then he will not have it.
It has been paid, probably
He is not updated. In case it has not been paid, he will come before you. In case it has not been paid.
No reply has been filed, so I am
No
not
problem,
aware.
no reply is required. And extra 4 you are represented before whom?
Before Regional Pay Commandant Account Officer.
Respondent number?
It is respondent number
4.
4.
The learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the respondents on instruction submit that all the admissible dues has already been paid to the petitioner, including the relief as prayed for by the petitioner in this writ petition.
It was paid at the time of supervision. Only this relief has been paid.
That's right, I've seen that.
Yeah, yes.
The learned counsel has, for the petitioner, has submitted that he does not have up-to-date instruction in the matter, and the petition was filed on 28/10/2023. Considering the aforesaid submissions made by the counsel for the parties, this writ petition is disposed of, enabling the petitioner to approach the respondent number 4 filing a representation in case the grievance involved in the present case has not been redressed so far. In such a case, if the representation is filed, the respondent number 4 shall to look into the grievance of the petitioner and do the needful within a period of 15 days from the date of representation. If any adverse order is to be passed against the petitioner, the same should be a reasoned order and be communicated to the petitioner through mail, through speed post. अगर एडवर्स होगा तो करिएगा, नहीं तो मिल ही गया है।
तो पेमेंट कर दिया इनका।
No problem. In case he has got any surviving grievance.
Item 22, WPS 6386 of 2023.
Yes, petitioner.
The issue pertains to departmental inquiry. The petitioner was issued charge sheet cum suspension order at
You are challenging the charge sheet?
Milord, on jurisdiction ground. Milord.
What jurisdiction?
Milord, there are some important development has taken
Straight
place.
come to the jurisdiction.
Milord.
Straight come to the jurisdiction point. What? How is it without jurisdiction?
Milord, page number 62 and page number 61, Milord. 2.3, Milord. Competent authority means an officer specially nominated by the chairman cum managing director concerned by an order in writing. For the purpose of these standing orders, such orders shall be put on notice board and copies sent to the concerned registered trade unions. Nomination has not been made by the CMD CCL himself, Milord. Rather
The nomination is on record.
No, this order.
No such nomination has been made so far.
My lord, this order sheet is on, this order passed by the competent authority, I mean, General Manager P and IR is on record.
No, I don't know.
And my lord, moreover, I am informed, my lord, this important development has taken place that the authority issuing the charge sheet, he himself questioning his competency to issue the charge sheet, has referred the matter to the competent authority, whether he was competent to issue the charge sheet or not, in view of the issues raised by the petitioner before the charge sheet issuing authority.
So therefore, you have raised your objection before the authority who has raised the, who has issued the charge sheet?
Yes, my lord.
And therefore, and he has also referred the matter to higher authority?
My lord.
Therefore, this writ petition is premature because let the higher authority take a decision on this.
My lord, during pendency of the writ petition.
That's right, very good. Now it has become infructuous because the higher authority is taking it into consideration.
During pendency of the writ petition, he has referred the matter to the competent authority. Inquiry has been kept on hold.
That's
right. This I have been informed, my lord, by the petitioner and the.
We can expedite. If that is so,
let me submit all the documents, facts and documents.
Your writ petition, you have already submitted facts. What else?
Recent development, my lord. Recent development. It will just and proper for adjudication of the case, my lord.
No adjudication is required because the matter is pending consideration before the higher authority. Isn't it?
But my lord, they have kept the inquiry on hold, and they will never be replied, my lord. I know they will never be replied, and the inquiry will be remain kept pending, my lord.
Just a moment. The learned counsel for the parties are present. The learned counsel for the petitioner submits that the writ petition has been filed challenging the jurisdiction of the authority who has issued the charge sheet. He has referred to page 61 of the
clause 2.3, my lord.
I have already noted. He has he has referred to page 61 of the writ petition, clause 2.3 of standing orders, and submit that the charge sheeting authority is not the competent authority in terms of the said clause. The learned counsel has also submitted that he has received instructions from his client that the inquiry officer that this point was raised before the disciplinary authority who has now referred the matter to higher authority for consideration.
Competent authority, not higher.
He has referred the matter to competent authority, who is competent to issue the charge sheet.
No, my lord. Competent authority might have referred the matter to GMP and IR.
He has referred the matter to higher authority for consideration of this point, and the matter is pending before the state authority. He submits that these facts are required to be brought on record by filing an affidavit. Counsel for the respondents is directed to seek instructions on this sort point.
The answer is at page number 63. Page number 62. Whether he is competent or not. In pursuance of and in terms of clause 2.3 of the certified standing orders applicable to all establishment of Central Coalfields Limited, the following officers have been specifically nominated as competent authority by the CMD. And 2.3 says CMD will nominate.
It is not a nomination by the CMD, my lord. It is never a nomination.
The learned counsel for the respondents is directed to seek instructions and file a short counter affidavit in the present case with regard to the subsequent, including and also respond to the subsequent developments which has been narrated by the counsel for the petitioner during the course of hearing of this case. The counter affidavit be filed by February 16th, post on 19th of February, under the same heading. You make this case infructuous.
Yes.
If there is a decision, you bring it on record.
Division bench has already decided.
Decided it?
Yes, sir.
Which is that order?
I will bring it.
Okay.
Item 23, WPS 6393 of 2023.
Yes,
In
petitioner.
this case, there are 5-fold pair mirror. First pair mirror, passing of annexure 8 mirror. That at page number 111. But this is Margdarshan. Guideline has been issued with regard to the promotion to the teachers mirror in grade 7 and grade 4. Lord, this is contrary to its own or various order issued by annexure 4, 5 and
Learned
5.
counsel for the parties are present. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case by 29th of February 2024. Pose this case on by 28th of February 2024. Pose this case on 4th of March. Is there any other petition of similar nature?
No.
Some more time.
Teachers are have become litigants because of you.
annexure 4, 5 में पहले जो
That much should be sufficient.
Item 24, WPS 6396 of 2023.
Yes, you would seek instructions from the secretary because it is a policy decision. Yes, I think that should be sufficient. Right. Otherwise, we'll give more time.
In this case, my lord, the counter will be filed by the respondent, my lord. He will file reply to that, my lord.
WPS number 6396 of 2023. Counsel for the parties are present. Time till, as prayed, time till 27 February is granted to the petitioner to file a rejoinder to the counter affidavit. Pose this case on 6th of March. Next.
My lord, let it be posted on 19th, my lord. This similar case has been posted for 19th, my lord. Arising out of the same.
Just a moment. Then rejoinder by you file by 15th?
We will file.
Post on 19th.
Along with
How many
WPS
cases?
6076.
WP
Yes.
number 6076.
2023.
The learned counsel for the petitioner has also submitted that. Similar writ petition being WPS number 6076 of 2023 has been directed to be posted on 19th of February. This case may be tagged along with the same. Let this matter be tagged with WPS number 6076 of 23. Next.
Item 25, WPS 6401 of 2023.
Next petition. What is the matter? Just a moment. What is the matter?
Matter relates to university. Termination university.
Counsel for the parties are present. Counsel for the response. Sorry?
Petitioner university working as a PTT in health department university. He terminated
Without show cause.
purely contractual.
Lordship, my senior is coming from that.
It's a purely contractual appointment. The contractual period is over.
No.
Why have you terminated? Making allegations or without allegation? Once it is allegation, you have to give show cause. Counsel for the parties are present. Counsel for the respondents pray for and is granted time till 19th February 24 to file a counter affidavit in the present case. Rejoinder, if any, by 23rd, post on 28th February. Next. 28th February.
Item 26, WPS 6435
If you
of 2023.
terminate a person by making allegation, Mr. Counsel, if you terminate a person by making allegation, even if it is contractual, you have to give show cause. The law is very simple, so you just satisfy on that.
So even the improved order doesn't speak of any show cause names.
We'll see. Yes, next.
Ashwati, annexure 7 is
Yes.
I was suspended. Subsequently, my suspension was revoked during the department petition proceeding. But one right has been put कि अनुपस्थिति अवधि के का प्राप्त वेतन 6 किस्तों में जमा करें. Now annexure 8 lordship, the department proceeding has been completed and I have been exonerated from this. But this order remains. Now they say कि आप 6
Counsel for the petitioner is present. Let a counter affidavit be filed by the state by 19th February. Rejoinder, if any, by 27. Post on 28th February. Sub under the heading for admission जाएगा all the cases. और other side को inform कर दीजिएगा.
Item 27, WPS 6436 of 2023.
आप kindly उसको ना जो previous case था उसमें counsel for the state को खबर कर देंगे. Yes, petitioner.
Yes. The matter relates, the petitioner has challenged the decision whereby the petitioners have been sought to be transferred election on the ground that there are surplus number of teachers in the district lordship. The improved order is at page
You're
45.
challenging the
and
order of transfer.
Yes, Your Lordship.
This case has been
it-
decided. This issue has been decided.
They are not ultimately been transferred, but the decision has been taken that they will be transferred. Your Lordship.
So
That
what-
decision we have challenged.
So, is there any legal bar?
Yes, Your Ladyship. Rule 1994 also, Your Ladyship, it does not stipulate the manner in which they have
The
been
manner is
subjugate-
another thing. Is there any legal bar of transfer?
Your Ladyship, the private persons have been involved in this decision that the teachers may be transferred.
Where do you see?
And, yes, Your Ladyship, it is.
And who is that private person?
Para 18, Your Ladyship, that the petition have been submitted that engaging private persons in the matter of transfer.
You have to make them specify the name of the person. It is absolutely vague.
Your Ladyship, in the minutes of the meeting, Your Ladyship, Annexure 5, page 43. The names are there, Your Ladyship.
This is local matter. Who is there? Who is the private person?
Attendees, Your Lordship, number 2, number 3, Shubham Sharma, program manager. Then number 3,
He's an
Nihal.
official
They are
person.
not the government persons, Your Lordship.
They are the persons concerned with the school and literacy.
Your Lordship, this institution name has been mentioned, which is PFEL, Your Lordship, and these persons are members of this private institution.
What is this PFEA?
This is a private institution. Your
You
Lordship.
tell us the full name. अब सुन लिया इनका बात. This has been filed on 21/11/23. It's a transfer matter. I am posting it on Tuesday. You file your counter affidavit on that.
Some more time.
Then I will stay.
Next.
Okay, WPS number 6436 of 2023. As prayed for by the learned counsel for the respondents, pose this case on next Wednesday. The counter affidavit in the present case be filed by Monday. Next Tuesday कर दीजिए. You respond to whatever she is saying, right?
Item 28, WPS 6437 up to 2023.
In this case, Your Ladyship, the petitioner has prayed for grant of particular pay scale of 8,000 to 30,500 in the petition in the light of resolution issued by the Finance Department dated 17/12/2007.
You have filed your representation.
Yes, Your Ladyship.
Where is
I have
that?
filed. That representation is at Annexure 4, page 21, and also Annexure 5, page 24.
Before whom have you filed?
Annexure 4, Your Ladyship, it has been
Before whom have
before the Secretary of Women, Child Development and Security, and Annexure 5 representation, it has been filed
Before the
to
Finance Department.
before the Principal Secretary, Finance Department.
First, the decision has to be taken by the
Finance Department.
by the finance department.
By the Finance Department.
Okay, and then only the okay, all right. So let them represent before the finance department. Counsel for the parties are present. This petition has been filed for the following relief. The counsel for the petitioner submits that appropriate representation has been filed before the respond number 1 as well as respond number 2, but no decision has been taken. Counsel for the respondent submit that though no counter affidavit has been filed in the present case, but appropriate decision has to be taken by the finance department, that is respond number 2. And he submits that the writ petition be disposed of with appropriate direction. After hearing the counsel for the parties, considering the nature of the relief as paid for by the petitioner, this writ petition is disposed of, enabling the petitioner to approach respond number 2 within a period of 2 weeks from today by filing a detailed representation giving the details of each and every petitioner. By separate representations by each petitioner. You are from different places altogether. Are you working in the same place?
Different place.
Different place, no? Yes.
Different place.
Separate representation by each petitioner giving the details of their claim along with a copy of the writ records. Upon such representation, the respondent number 2 shall take a decision in the matter based on applicable circulars, rules, etc. governing the petitioner. The decision be taken within a period of 4 months from the date of the representation, and by reasoned order, the reasoned order be communicated to the petitioners through speed post. Petition is accordingly disposed.
One judgment is there whereby similar issue has been decided.
You annex along with the representation, whatever.
Item 29 WPS 6440 of 2023.
In this case, your leadership counter has been filed. I was just requesting for 2 weeks time to
Counsel
file
for the
rejoinder.
petitioner prays for and is granted time till 28th of February 24 to file a rejoinder to the counter affidavit. Post this case on 6th of March under the heading for admission. All these matters will go for admission.
Item 30 WPS 6443 of 2023.
Petitioner? Yes? Yes, petitioner? Counter would be required. Counsel for the respondents pray for and is granted time till 6th of March 24 to seek instructions and file a counter affidavit in the present case. Let notice be issued by registered by speed post as well as by speed post to respondent number 6. The requisites be filed within a week from today. Thus in addition, post this case on 18th of March 24, awaiting service report. The petitioner, the supplementary affidavit regarding service of notice be filed by 4th of March under the heading for admission. Are you there in this case? Are you appearing? Who is for the petitioner? You kindly inform me.
Item 31 WPS 6445 of 2023.
Yes, petitioner.
I should, in this matter, the advertisement is 2018. Now this is for the post of assistant professor subject Kurmali. The result was supposed to be published after the taking interview in the month of December 2022. June 2023, they have come up with the impugn order at Annexure 8, that is page 56, merely saying that for unavoidable circumstances, the interview is cancelled. So it was all process has been completed. This is advertisement 2018.
You were ultimately you were never interviewed.
No, interviewed. Only 2 posts are there for this particular subject, and 3 persons have been interviewed. And now they say there is an unavoidable circumstance. Without citing any reason whatsoever, 56 order has been passed. And they are completely sitting tight over it. No fresh notification for
Yes, what is the reason why have you cancelled it?
Your Lordship, there was oral instruction, Your Lordship.
Yes.
No, there was defect in the composition of the interview. Oral instruction, what they have.
You file your short affidavit. You can file it by Monday. It's a very
that
short
will
affidavit.
take time, At least 3 weeks, Your Lordship.
3 weeks to put this on record.
There should be in similar circumstance for other subject also. There is an undertaking given by the GPSC saying that we will be publishing the result, and later on,
I don't know, altogether
civil review has been filed.
lecturer
The learned counsel for the parties are present. The counsel for the respondent, JPSC, prays for and is granted time till 28th February 24 to file a counter affidavit in the present case. Rejoinder, if any, by 4th of March, post on 5th March under the heading for admission.
Item 32 WPS 6447 of 2023.
Yes, petitioner.
therefore correct the date of first time on promotion granted to the petitioner.
Date of first time on promotion.
That was granted, only correction is required. Since from the date of appointment it has not been calculated, from the date of pay scale they have the pay scale granted
Counsel
to
for the
petitioner.
parties are present.
And similar
Counsel for the
issue has already
respondents is
decided
directed
by-
to seek instructions and file a counter affidavit in the present case. The counter affidavit be filed by 28th of February, rejoinder if any by 5th, post on 6th of March.
Sharing for
Under the
respondent
heading
number
for
7.
revision.
I'm sharing for respondent number 7.
Give you also file your counter affidavit.
Item 33 WPS 6451 of 2023.
Petitioner.
But they have paid for their regularization of services. I'm appearing for respondent number 2, the regulatory commission.
They are working on contractual basis.
They are working on the contractual basis. But similar other matters have also been filed by claiming
Give
for
us a list, please.
But the lead case is WPS number 3546 of 2023.
3546
of 2023.
23. How many matters are there?
Like 7 cases.
All of
more
23? All of 23?
All for regularization, all for the commission and
For
the
2023?
of 23.
Okay, give the list.
I'll give them.
Right. Okay. You have filed counter affidavit in any of the case?
Well, in all those cases I have filed.
You
But
filed
this
here
case is
also?
This case is coming for the first time, Lord.
You filed in this case also?
I will
Right. WPS number 6451 of 2023. Learned Counsel for the respondents submit that the following cases involve same issue of regularization in regulatory
For electricity, Jharkhand State
in
Electricity Regulatory
Jharkhand
Commission.
State Electricity Regulatory Commission. The petitioners are contractual employees. He submits that in the other cases, in the other similar cases, counter affidavit has been filed. He shall file a counter affidavit in the present case also, and he submits that this case be tagged along with the aforesaid cases. उसमें सब एक साथ हो गया?
Lordship, they have already tagged. Only
They have
this was-
already been tagged.
Only this is in
Any date fixed?
No, ma'am, no date fixed.
एक date देखिए, tentative date देखिए इसका 3546 और 23
Of 23.
देखिए tentative date क्या है इसका?
डेट नहीं दिया.
Okay. Pose this case along with the other writ petitions which fall in the roster of this bench. Along with the aforesaid writ petitions.
May I submit, madam? Rather, in one of the dates, it was placed that similar matter is also pending before the division bench in LPA number 282, my lord.
We'll see that.
Well, because that was indicated in one of the order that it should be.
We'll see that.
Lordship.
What happened to that LP?
That is still pending. I believe, ma'am, that is going to be listed on 15th of February regarding regularization.
Okay.
It's an appeal preferred by the state.
All right. Now, pose this case on 28th of February 2024. The counter affidavit, along with the aforesaid cases, the counter affidavit be filed in the present case by 16th February. It's a local matter. Rejoinder, if any, by 22nd.
Item 34 WPS 6463 of 2023.
But not in this case, matter relates to payment of revised base.
Revised
This is
base.
what counter is ready. but
Ready? Okay. Is it, you have filed it? You can file it right now?
Well, today.
Okay. WPS number 6463 of 2023. Are you opposing or supporting?
Entitled petitioner were not entitled to revise.
Counsel for the respondents is permitted to file the counter affidavit in the present case during the course of the day. The rejoinder to the counter affidavit be filed by 28th of by 23rd of February. Post this case on 28th of February 24.
It may kind of permitted.
Yes, sir.
Item 35 WPS 6477 of 2023.
Yes, petitioner.
Milords, matter relates to appointment of primary school trained teachers, Milords. The prayer of the petitioner in the state case, Milords, for inclusion of the psychology subject in the eligibility criteria in the appointment of the teachers, my lord. Wherein, my lords, at graduation level, in social science teacher, my lords, at graduation level, the honors subjects are prepared history, geography, political science, economics.
No, what you see, you cannot file a writ petition like this unless there is some circular, some decision of the government that your subject will be included. Is there any policy decision that it should be included? You want psychology to be included?
Milords, in the earlier examination, Milords, this subject was included.
They don't want to include it. It's absolutely their prerogative as to how the recruitment process has to go. Because psychology as a subject is not taught in schools.
So
Psychology as a subject is not taught in schools.
A prayer has been made before the secretary concerned to include, as because as per the eligibility criteria of this subject, my lord, this particular petitioner has qualified the JTET examination held in the year 2016.
Still,
and at that time he was
that's
found
fine.
eligible.
That's fine. He was found eligible and he has done it and everything is okay. But psychology as a subject is not being taught in the school. Therefore, we can't force them to include your name, persons who are doing psychology, as a part of, teachers to be recruited for the purpose. Those students who have studied history would be better suited rather than psychology students, isn't it?
But
it is absolutely in the domain of their policy. It is absolutely in the domain of this policy. We can't issue any direction. You can pursue your representation, whatever you have done.
I have made representation before the.
You pursue it, but we cannot issue a mandamus.
Still, my representation is pending there, my lords.
It is essentially a policy matter.
They may be directed to take decision on my representation at the earliest, and
where is your representation? You'll consider it. Whatever it's essentially a matter of policy. Sorry.
At page 101, my representation.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel.
I am not pressing the relief one.
Yes. The counsel for the petition submits that he does not press prayer made in para 1 within bracket Roman 1. The learned counsel has submitted that the petitioner before this court has his educational qualification in the field of
psychology. BSc, BA honors in psychology.
BA honors in psychology.
And B.Ed. And also
and B.Ed and is also qualified
JTET in the year
as JTET in the year 2016.
And thereafter no examination.
He submits that so far as the subject of the petitioner is concerned, the respondents have not been including the said subject in the advertisement.
Yes.
In the advertisement, and therefore the petitioner, being duly qualified in all respect, is unable to participate in any of the selection process. He has submitted that he has filed a representation before respondent number.
Secretary.
Respondent number 3.
Respondent number 3, but no decision has been taken so far.
Because the Department of
Okay.
School.
Respondent number 2, but no decision has been taken before the concerned respondent, but no decision has been taken so far. The learned counsel for the respondent submit that essentially the matter relates to policy, and therefore no mandamus will be issued. But if a representation has been filed, the same can be taken care of by respondent number 2. That is it. Considering the submissions made by the counsel for the parties, this court is not inclined to issue any mandamus for the purposes for the relief as prayed for by the petitioner. But since the petitioner has represented before the respondents, raising his grievance, if the respondent number 2 raising their grievance, the same can certainly be addressed by respondent number 2 as submitted by the counsel for the respondents. Considering the aforesaid aspects of the matter, since a representation has been preferred, the petitioner may pursue his representation before respondent number 2 for appropriate decision. This writ petition is accordingly disposed of.
Item 36, WPS 6478 of 2023.
Petitioner.
This case of mine, my lord, is squarely covered by the two decisions, my lord, penned on by this honorable court day before yesterday.
Okay, same.
Same, my lord, these are the two. I have come with the status report of those two decided cases.
Where is it?
No, it's a matter of employees of the BSRTC, my lord, who have been allocated the cadre of the state of Jharkhand. And then, my lord, the state has come out with the notification, my lord, issued in the Jharkhand Gazette by virtue of
This has been decided by whom?
Decided by your lordships, my lord, day before yesterday.
Second half में इसको पता करिए कहाँ? इसको second half में रखिए.
Day before yesterday at serial number 37.
अब भी हो जाएगा, हो सकता है अपलोड हो गया होगा. अपलोड नहीं हुआ?
नहीं हुआ इसलिए.
अभी हो जाएगा, लंच में हो जाएगा. ऑर्डर लेके आएंगे. Next.
Item 37, WPS 6498 of 2023.
Yes, petitioner है कोई? Considering the nature of relief in the present case, let a counter affidavit be filed by the respondents. By 28th of February, rejoinder if any by 6th March, post on 13th of March under the heading for admission. स्टेट है ना, काइंडली बता दीजिएगा, जो भी काउंसिल हैं उनको बताते जाइएगा. किसी का एब्सेंस नहीं रिकॉर्ड कर रहे हैं, 2 बज रहे हैं इसीलिए. आई डोंट वांट टू रिकॉर्ड एब्सेंस ऑफ एनीबॉडी. नेक्स्ट.
Item 38, WPS 6541 of 2023.
Yes, petitioner. ये तीनों केस जो बचा है ना, सप्लीमेंट्री एफिडेविट में करके डाल दीजिए.